And get this session started. If we could be called to order. Sergeant Arms will please secure the chamber doors. Members, please take your seats. Madam Clerk, please call the roll.
Mr. President.
All right, Senators, on this very beautiful March 18th, we are very pleased to have back with us today Reverend Scott Shelton of Heritage Baptist Church in Annapolis, Maryland, guest of the distinguished senator from the capital city. Please rise for the invocation.
I wrote this yesterday. It's called Wednesday, middle prayer of sorts. Some weeks we are trapped in the middle when life is in an undistinguishable riddle, when political change is like learning to pick a fiddle. Behind us, yesterday. Thoughts of a good old day help us to pray, but its trap can keep us stuck like clay. So we walk, forward is the way. On our shoulders is now. The weight of today's plow keeps us wondering how. Help us not forget our long-term vow. So one day we'll look back and say, wow. Ahead of us, tomorrow. In the throes of the fast-paced tempo, the escalating workflow, let us not be afraid to enter the micro. Don't let us leave our calling in escrow. Guide us on this day in the middle of session. Fill this room with people brave enough to ask the deep question. Minds and bodies alert to freshen. Spirits alert with great discretion. Everyone ready to take possession. Right in the middle, because accession for all people is today's obsession. Amen.
Well done. Thank you. That was wonderful. Recognize the senator from the capital city.
Thank you, Mr. President. We are so proud and grateful that Pastor Scott continues to grace us with his presence here. He is a local pastor, so because Heritage Baptist is here in Annapolis, he's able to fill in for us when we have pastors that are not able to make it. Since Pastor Scott will be able to frequently join us, I want to just share a few facts about Pastor Scott so that we can get to know him. Pastor Scott, amongst his favorite books are The Divine Conspiracy and Into Thin Air. Amongst his favorite foods are Tex-Mex, Chinese, and pizza. His favorite season he describes as football season. And his favorite scripture is John 10:10. And now we know he is also a prolific rhymer. So with that, Mr. President, I would ask that that wonderful invocation be journalized.
Without objection, most certainly, Senator, we will do that. And it is a pleasure to be stuck in the middle with you, right? Excellent. Very good. Very good. All right. Let's see. Has everybody recorded their presence today? Has everyone recorded their presence? Looks like we're missing a couple. Almost. All right. Getting there. Slowly but surely. All right. The clerk will take the call. With 44 members in the chamber and a quorum being present, the Senate of Maryland is again back in session. Let's start with the senator from Montgomery and Howard counties. We have some guests for resolutions. Let's start with the first one.
Thank you, Mr. President. Colleagues, I rise today to recognize the Glenelg High School boys soccer team for an extraordinary championship season. In the Class 2A state championship, Glenelg delivered a dominant performance, controlling the pace of the game and securing a decisive 4-0 victory. Colleagues, they were 17-0 this season to take the state championship. From start to finish, the team exemplified teamwork, precision, and composure under pressure. Please join me in congratulating Vishnu Amli on behalf of the Glenelg boys soccer team on an outstanding state title. We are so incredibly proud of you.
All right. Clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to the Glenelg High School boys soccer team in recognition of winning the 2025 Class 2A Maryland State Soccer Championship. We applaud your outstanding season and wish you many more. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 18th day of March 2026.
Clerk will call the roll.
Mr. President.
Has everyone recorded their vote? If so, the clerk will take the call. To the Glen Elg High School boys soccer team, congratulations on your 2025 Class 2A Maryland State Soccer Championship. Congratulations. But wait, there's more. Back to the senator from Howard and Montgomery.
Glenelg had a really good year, colleagues. I'd like to take a moment to honor the school girls volleyball team for capturing the 2A state championship. In their championship against Williamsport, Glenelg rose to the occasion in a hard-fought contest, showing poise in critical moments. Their ability to stay composed under pressure was the difference maker on the biggest stage, leading to their win over the 17-time championship winner, Williamsport. So Williamsport now is 17-1 against Glenelg in the past 20 years. So this victory reflects their dedication and their unity as a team. Please join me in congratulating the captain of the girls volleyball team, Avery Hubbard, here on behalf of the team. Congratulations.
The clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to Glenelg High School girls volleyball team in recognition of winning the 2025 Class 2A Maryland State Volleyball Championship. We applaud your outstanding season and wish you many more. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on the 18th day of March 2026.
Clerk will call the roll.
Mr. President?
Has everyone recorded their vote? If so, the clerk will take the call. To the Glenelg High School girls volleyball team, congratulations on your 2025 Class 2A Maryland State Volleyball Championship. Well done. But wait, there's more. Back to the senator from Montgomery and Howard.
Thank you very much, Mr. President. Colleagues, I'm also proud to recognize the Glenelg High School girls field hockey team for their incredible postseason run. In one of the defining moments of the season, Glenelg secured a dramatic victory over Manchester Valley, with Lakshmi Almley scoring in overtime to put the score 2-1 and win them the state championship. Their performance demonstrated their resilience and their refusal to back down. Please join me in celebrating Lakshmi on behalf of the Glenelg girls field hockey team. Congratulations and go Gladiators.
Clerk will read the resolution in full.
Be it hereby known to all that the Senate of Maryland offers its sincerest congratulations to Glenelg High School girls field hockey team in recognition of winning the 2025 Class 2A Maryland State Field Hockey Championship. We applaud your outstanding season and wish you many more. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 18th day of March 2026.
Clerk will call the roll.
Mr. President?
Has everyone recorded their vote? If so, the clerk will take the call. To the Glenelg High School girls field hockey team, congratulations on your 2025 Class 2A Maryland State Field Hockey Championship. Well done. Congratulations. I think we need to check the water at Glenelg. It's Senator from the 26th.
Thank you very much, Mr. President. I want to ask the young man here, whose team did you all beat to win?
Folsom. Ah.
I need you to get up and get out and never come back. That's all right. Thank you, Mr.
No,
President.
thank you all. All right, congratulations, and keep up the great work on the field and in the court and in the classroom. Keep both places to excel. All right, Senators, we also have another resolution, a exciting and sad one at the same time. We are so incredibly thankful for the great work of Deborah Timonello Feely, who for the last 24 years has been dedicated her service as facilities manager here for the General Assembly and the Department of Legislative Services. She's consistently ensured that our facilities remain operational and well maintained, and she has regularly assisted with event setups that all of us have benefited from. She has gone above and beyond, assisting the Senate in many ways, including painting and carpeting on her own, with her own time, really just to make it right, and just most recently was working on the cafe and kitchen renovations. Debbie has contributed her expertise as a member of the project team for the entire DLS rebuild. I don't know how we possibly could have done it without her. She's joined by her children here today, and I'm just, if we could please give her a heartfelt Senate thank you for her incredible, incredible work, and wish her well in retirement. We'd also ask the clerk to read the resolution in full.
Be it hereby known to all that the Maryland General Assembly offers its sincerest congratulations to Deborah Tumanello Feely in recognition of your retirement after 22 years of dedicated and exemplary service as the facilities manager for the Maryland General Assembly. The entire membership extends its best wishes on this memorable occasion and directs this resolution be presented on this 18th day of March, 2026.
The clerk will call the roll.
Mr. President,
Has everyone recorded their vote? If so, the clerk will take the call. Again, Debbie, the Senate of Maryland unanimously celebrates your incredible work and thanks you for your service and for your entire team. I know you're joined by many of the incredible folks at DLS who I know are sad to see you go, but wish you the best in retirement. Again, congratulations and thank you. Thank you, thank you. All right, I think that does it for resolutions this morning. Senator from Montgomery County?
Thank you very much, Mr. President. Mr. President, today I rise, well, first of all, good morning. Tomorrow, I serve on the Governor's Well-Mobile Advisory Board, and tomorrow on College Avenue from 9 to 2 p.m., they will be doing wellness checks for the legislature and the staff. As you know, they've been doing a great job since 1994, especially providing primary care and nursing care to areas of the state that don't often get it. We're grateful again to have them arriving to Annapolis tomorrow, where we'll welcome them again. But please, if you and your staff would like to be checked out for wellness, you could do so tomorrow on College Avenue from 9 a.m. to 2 p.m. Thank you, Mr. President.
Thank you, Senator. Recognize Senator from Montgomery County.
Thank you very much. Thank you very much, Mr. President. We have some extremely distinguished guests in the gallery. We have 17 fourth-class midshipmen, commonly known as plebes, not cadets. And in the coming weeks, they're accompanied. They're 17. They're here as part of the American government course. They're accompanied by their professor, Alan Friedman. But in the coming weeks, as they conclude their first year, they're going to take part in one of the Academy's most storied traditions, which is the Herndon Monument Climb. And once they complete that climb, they will officially conclude their plebe year and advance on to their next stage of their career at the Naval Academy. So it's my honor to introduce these 17 patriots, and if you could welcome them today as they watch government in action.
Wonderful. Well, welcome. It's a pleasure to have these midshipmen with us today, and we wish you good luck is it next week? Next month. Okay. Very good. Well, welcome. Thank you all for joining us today. Thank you. All right. Yes, Senator from District 6.
Thank you, Mr. President. Today, everybody, we have the members. We have 51 throughout the campus here, and they will be visiting, but the members of the Maryland wing of the Civil Air Patrol are visiting with us today. If they could stand. The Civil Air Patrol provides critical services such as research, the rescue operations, relief for disaster, reconnaissance, and damage assistance during emergency situations. They play a pivotal role with leadership training, aerospace education, and other types of training also as well. 51 members will be here throughout the day. They'll be visiting. So I want to thank them first of all for being here and welcome. Check us out. We're going to be going at it today. And if we could all give them a Senate welcome, I appreciate it, Mr. President.
Welcome. Thank you to the Civil Air Patrol. Wonderful. Yes, Senator from the 38th.
Thank you, Mr. President, colleagues, friends, everyone who's in the chamber today. Crisfield High School students, if they would stand, please. And please welcome them. Many of them woke up 4:30, 5 o'clock this morning to join us. The Crisfield Crabbers already this morning have experienced a little bit of our committee hearing room to get an update of where the work is done in the Senate Education, Energy, Environment Committee, and they'll be observing our proceedings today. And I want to thank them for making the extra effort. This is 5 years in a row. Mr. Laird and Mrs. Jackson have brought the group up. So welcome. We really appreciate you making the extra effort to be with us today. Thank you.
Excellent. Welcome to the Crabbers. Welcome. Thanks for joining us today and crossing the bridge. Thank you. All right. Senator from Montgomery County.
Thank you, Mr. President. I have another shadow today. Please join me in welcoming Catherine Prather. She's from West Virginia, but she's a sophomore at Johns Hopkins, where she is double majoring in economics and materials science and engineering, which just sounds complicated to even name. She's an advocate for people with disabilities on campus, and I met her in Chicago, where she was the youngest delegate to the Democratic Convention in 2024. Please join me in welcoming her to the Senate today.
Welcome. Thanks for joining us today. Welcome. We're going to Senator from Montgomery County, followed by the Senator from Baltimore County.
Thank you, Mr. President. I'm so short back here, you can't see me. Today, I'd like to welcome a great group of people from Montgomery County, the Gaithersburg Germantown Chamber of Commerce. It's their Economic Development and Legislative Affairs Committee. Wonderful to have you here today to watch us in action.
Welcome. Thank you for joining us. Thanks for being here. Senator from the 44th.
Thank you, Mr. President. I wanted to ask for a warm Senate welcome to my daughters who are here spending the day with their father to document what he does here at work while they're on spring break from Retriever Nation. Cameron and Kaylin Sitnor. And since we were talking about Retriever Nation, what a game last night.
I know.
3 short,
I
but
know.
you know, they won their regular season and also the tournament. So I mean, they certainly made Maryland proud in District 44. So anyway, welcome to my children.
Absolutely. Welcome, welcome. Your dad talks about you all the time, so please know that when you're not here, he's talking about you. So all good things, all good things, all good things. Yes, recognize the protocol chair.
Thank you, Mr. President. I suspect that the senator from Baltimore County may have family here because permission to use the senator's name. It is Senator Charles Sidnor's birthday today, so if you can give him a round of applause.
Hey. And we wish him the happiest of birthdays. No place he'd rather be, especially with his daughters here. I mean, come on, you know, what else could you ask for? Senator from Baltimore City and County.
Thank you, Mr. President. Today, I'd like to welcome Mercy High School. I believe they're joining us today. Very good. I myself went to an all-girls high school in Philadelphia, so please give them if I grew up in Baltimore, of course, I would have gone to Western. But please give them a warm Senate welcome.
Welcome to the young ladies of Mercy. Welcome. Senator from the 22nd.
Thank you, Mr. President. I would hope that can the body please join me in giving a warm Senate welcome to my shadow of the day, Jonathan Jordan. He is the son of Janelle Jordan, who's a good friend of mine, and we started on a Democratic Central Committee together. And he's a sophomore at a school in Virginia, but he lives in Cheverly, Maryland, and a very smart young man. He plays on the football team, and he has a 3.8 GPA.
Excellent.
Please give him a round of applause.
Very good. Welcome. Keep up that great work. Very good. We are also joined today by the doctor of the day, who's a 46th District resident, no stranger here, Dr. Erin Murray, who is with Anne Arundel County. She practices rheumatology, or practices in Anne Arundel County. So if we could please give her a warm Senate welcome. Thank you all. Thank you. Any further introductions before we jump into the work today? If not, so be considered the reading of the journal from the prior legislative day. We have a busy day today of a lot of stuff. We're going to do as much as we can. We'll see what time we break, probably, I don't know, we'll see, 1-ish, somewhere in that realm. And then we'll probably come back today around 4:35, so as we're kind of just thinking about schedules for the day. We're going to start with judicial proceedings, though. We're going to go to report number 12. Clerk will read the first bill.
Senate Bill 111, Senator McCray, Vehicle Laws, Out-of-State Vehicles, Improper Registration, favorable with 8 amendments.
Recognize the Vice Chair of the Committee as the floor leader.
Thank you, Mr. President. As amended, this bill alters provisions related to the enforcement of the requirement that motor vehicles owned by residents of the state be properly registered in our state. There are 8 amendments. Amendment number 1 is technical. Amendment number 2 adds provisions authorizing MVA to take possession of certain illegally displayed registration plates. Amendment number 3 adds provisions of a departmental bill authorizing the administration to enter into reciprocal agreements. Amendment number 4 exempts trailers. Amendment number 5 prohibits tag and title companies from selling out-of-state registrations. Amendment number 6 authorizes parking enforcement agents to take possession of illegally displayed plates. Amendment number 7 alters provisions of the bill authorizing the administration to send warning notices. And I'm not used to amendments going on a second page here. Amendment number 8 substitutes the county attorney for the state's attorney and provisions related to the enforcement of the bill. Mr. President, I move the favorable committee report and the 8 amendments.
Floor leader moves for the adoption of the 8 committee amendments and the favorable committee report. On the amendments, recognize the minority leader.
Thank you, Mr. President. If the floor leader would please yield for a couple
Senator may proceed.
Just as you mentioned, a number of amendments that are on it now. Can you just kind of briefly now explain what the bill does specifically with respect to out-of-state?
Sure. We merged a number of bills that were before us, all dealing with illegally registered vehicles, and we took them all and put them in one omnibus bill. So to the extent that you see a lot of amendments, that's because it's combining a departmental bill, the senator's bill, as well as some other legislation dealing with the problem of illegal registration. There is no one silver bullet to solving the illegal registration problem, so it takes a number of solutions and puts them all in one bill to address the illegal registration of out-of-state vehicles in Maryland by Maryland residents.
Okay, and then when you reference the illegal registration, that is specifically a Maryland resident with
That's correct. It is illegal under current law for a Maryland resident living in Maryland to register a Maryland vehicle in another state. But we don't have enforcement mechanisms to enforce that law. So this bill combines a series of enforcement mechanisms to ensure that people who are registering their cars in Virginia, in North Dakota, or elsewhere have consequences for doing so here in Maryland.
Okay, and can you just explain a little bit what that enforcement looks like now with respect to this omnibus bill?
So it's very difficult to enforce right now under current law. What this bill does is it has 2 primary mechanisms. First, it provides enabling legislation so that MVA can sign reciprocal agreements with other states to ensure that they are not registering the vehicles of Maryland residents. So right now, Virginia allows Maryland residents to register in Maryland. MVA, this would provide enabling legislation so that Maryland MVA could go to Virginia and make an MOU or some type of agreement between the 2 states so to prevent Virginia from registering their vehicles in Maryland vehicles and vice versa. It also provides for better enforcement of a tag pickup order. So MVA can flag your vehicle as being improperly registered in another state, but that tag pickup order is not particularly enforceable under current law. This provides enforceability of the tag pickup order.
And just, 'cause I have a couple questions related to what you just said there, but on the last one first, how is it recognized then for MVA to take this action to flag a vehicle?
So they're using their back-end information. MVA in Maryland, because they are sharing data with other MVAs, knows when a Maryland resident with a Maryland address registers a vehicle in Virginia. They can see the change from the original Maryland registration to the Virginia registration. And if you are a Maryland resident and you have not changed your address, MVA has knowledge of that. They currently, under current law, already do that flag. The flag is not anything new, but basically they send warning letters to Maryland residents. Without an enforcement mechanism, many Maryland residents are throwing that in the trash.
Okay, and again, with enforcement and finding out, this isn't something that a neighbor sees a vehicle in your driveway that has Virginia tags on it and they make a call to the MVA or something. I mean, that's not...
That's correct. There's no citizen enforcement or complaint involved here.
Okay, and then with respect to you saying this reciprocal agreement with Virginia, are there a number of Virginia residents that have vehicles that are tagged in Maryland? Are they seeing this same type of problem as well?
I don't believe so. I think it is a unique feature of Virginia law. I think there may be 1 or 2 other states that allow you to register vehicles when you live out of state.
So that's why I'm wondering then, why would Virginia want to participate in this agreement if they have figured out a way to I guess, bring additional revenue into their state, the same way that Maine kind of does things with trailers, right?
Correct. Yeah, so the answer to that question is because many of these drivers pose a severe risk to public safety, including in Virginia. And so people aren't just registering in Virginia to save registration fees in Maryland. They're registering in Virginia because they have accumulated fines and fees from dangerous activities. So you can get 40 automated tickets in Maryland for going 100 miles per hour, and when that ticket comes due, when it's time to re-register your car in Maryland, Maryland will not re-register it unless you pay those fines and fees and are accountable for your bad actions. Those people then go to Virginia, re-register in Virginia to avoid the consequences of their bad actions in Maryland. Eventually, someone's going to get killed. And Virginia knows that just as well as Maryland. And the new Virginia administration has shown an openness to closing the loophole that they've created.
Okay, and I think partially I agree with partially. I think that's a little extreme because I've heard a little bit of the same that as a representative of the Eastern Shore, when the tolling facility went from a person-operated tolling facility to automated tolling facility, and they changed the vendors, that there was this big problem. And I know my colleagues in Baltimore City had recognized some of this as well with some of the problems that we've all tried to work on with Easy Pass and the tolling. And some of that has been able to be worked out. But a lot of this also went to CCU. And once it's in CTU, I know we've tried to talk about legislation, but once it's in CTU, MVA really doesn't have any real opportunity to make much adjustments to it.
Senator, you want to explain or spell out CCU?
Central Collection Unit. I would say CTU.
CCU. You said, Senator,
CCU.
correct.
Sorry.
Just Central Collections.
Yeah, Central Collection. Sorry, CCU. And so what I was here, or what I know a number of us have heard the problem that once it's in CCU, that you can't really negotiate anymore. It's an astronomical amount of not just the toll violations, but the fines on top of that, and then the extension for the period of time, that actually many people are going to Virginia just in order to keep their vehicle legally registered. So, I don't think it's all just big speeding and unsafe people. I think it's really, everyday people that have gotten into a position because of a mismanagement of our tolling in our Easy Pass system has brought them into a situation that they really don't have any other options on what to do, and they've sought out the one state that allows them to do that. So, and that's what just gives me some pause on this, is that yes, I understand that we're trying to have people not register their vehicles in other states. I do think it's a little bit, again, certainly Maryland would love to see that revenue come back to the state with respect to vehicle registration fees, but I am concerned about the broader problem on why some people are doing this. And I don't know, again, if we had a bill this year, again, I know the senator from Budget and Taxes worked on this Easy Pass issue, but I think we need to make sure we address the issue with the Central Collection Unit as well, to make sure that these people do have the ability to register in state when that's the only real reason that is prohibiting them from doing it, is they can't get out of that debt.
Senator, I agree 100%. I know there is legislation on that very topic that has been submitted this year. We had a hearing on it, and my hope is that that bill moves forward as well.
Much appreciated. Thank you very much.
Thank you. All right, recognize the senator from the 28th District.
Yeah, thank you, Mr. President. Question for the floor leader.
Senator, may proceed.
Yes, sir.
Thank you, Mr. Vice Chair. So in Maryland, we have many thousands of military active duty folks who come in and out of the state of Maryland. When I was on active duty stationed throughout the country, I was able to keep my New York plates, and with no problem. Does this legislation have a carve out for the military active duty folks?
Yep, we are being told that carve out exists under current law.
Okay, the carve out exists on the current law. So with the increased enforcement, people see police officers out of state plate, park at a spot, how will they know this is an active duty veteran, don't give them a ticket, i.e., because that could be quite harassing if we have a more robust law and, you know, police officer pass a particular community and see these out-of-town plates, even Virginia residents, they follow on the same law. What provisions are in place for the officer to know that that's an active duty military person? Because when I was on active duty a few years ago, we had these tags on our cars, but because of terrorism, now we don't want people to know that you're in the military, so those tags are gone. So there is no indication that that car actually belonged to a active duty military person. So any provisions to make sure individuals are not really given tickets after tickets and they have to keep going to court time and time again?
Yeah, so really good question. So first of all, under the provisions of the bill, this does not allow you to pull any police to pull you over for any reason. This is an administrative process that is done through the MVA. If for some reason the MVA were to mistake it, so MVA will not flag active duty folks with a tag pickup order under the WARN Act, but if for some reason there was an error and MVA did flag active duty under the WARN Act, all you would have to do is indicate to the MVA that you're an active duty soldier and that flag would be removed.
Yeah. So my scenario, thank you for that answer. So my scenario, someone is living in an apartment complex and they park like on the street. A police officer frequently go up and down that street and they see that, say, Virginia tag continually. Does the police officer then can give a ticket or to that car that they see?
They cannot.
They cannot.
The entire basis of the bill is an administrative process whereby MVA flags a registration from for a Maryland resident to an out-of-state registration. That flag is what triggers this process. Without that flag, no one can take any action. And even with that flag, police cannot take action on their own.
Okay. So thank you. So the flag would be, say, we have a sharing agreement with, say, Virginia, and we know tags, people who are registered in Virginia, and they have a Maryland address. I'm not sure how that flagging works. Could you explain that?
So I just want to be clear. This does not create a new traffic offense. There is no way a police officer can pull you over because you have out-of-state tags. People with out-of-state tags are obviously constantly driving through Maryland.
Correct.
There is no new traffic offense created. There is no new interface between police and drivers created in this bill. It's not just that you have changed your mailing address to Maryland if you're active duty. In order to get flagged at all, you would have to change your driver's license, which is how the MVA is defining where you live.
Okay.
If you changed your license to Maryland as an active duty soldier, you're covered under the WARN Act, and MVA would know that. If for some reason you were mistakenly flagged by the MVA, that would create an administrative process. They'd send you a letter and you would just indicate, hey, I'm actually active duty. I'm covered under the WARN Act. This doesn't apply to me. MVA would remove the flag.
Yeah. So thank you, Mr. Vice Chair. So the end result of this discussion is our military members, active duty members stationed in Maryland from all over the country will not face any continual action and notices from whether it's MVA or officer driving by.
That's correct.
Okay. Thank you for that assurance.
Thank
you, Mr. President.
Thank you, Senator. Our midshipmen were moving from one side to the other, so we may have to repeat that as they come back in, as they soon to be active duty, so they know that the rule will apply to them once they graduate too. Yes, recognize Senator from the 45th, the sponsor of the bill.
Thank you, Mr. President. I just wanted to speak on the bill and just
Please.
say, I think it's important to say thank you. I think that a significant amount of work went into this bill. It took over 45 days for it to come out of committee. I appreciate my colleagues' discussion on it when we think about the military veterans, military folks, but it's not just military folks, Mr. President, it's also college students. They were already exempt from these specific things. No one's being pulled over by the police. It's triggered at the MVA. They have an investigative department. They have notifications that go out. There's a very professional process that goes into this work that happens. very sensitive in reference to CCU, but it's not just CCU, it's child support. It's anything related to taxes that's caught up in these things. But what I would like to say, Mr. Chair, Mr. President, is when I think about like just the challenges that we're facing on the streets, we're seeing drivers drive very erratic. We're seeing people that did nothing. They had insurance, but what happens is we're having to tap into uninsured motorists because the other person with these respective tags do not have insurance. Mr. President, I'd also like to lean in and say that we've seen fatalities with out-of-state registered vehicles increase over this period of time, and it is getting very challenging where our constituents are now reaching out to us and saying, you're lawmakers, we need you to do something for things that we did not inflict on ourselves, but making sure that we can move forward. I thank you again because you took in consideration of the folks, the farmers or people that may have trailers and things of that nature and said they are a different class and they are not the intended people that's causing consequences out there. So I just say thank you to the entire Judiciary Committee for putting out a very respectful
Judicial proceedings.
Judicial proceedings.
Yes, thank you, Senator. No, thank you. Appreciate that. Thank you. We're going to Senator from the 32nd, followed by the Senator from the 5th.
Thank you, Mr. President. Will the floor leader yield for a moment, please?
Senator may proceed.
Of course. Thank you. Was there any discussion about the insurance issues that happen when people come in, vehicles tagged from out of state, that they're not carrying the required insurance?
Absolutely. That is one reason people go out of state, because they don't want to carry the required insurance. As the gentleman indicated, that creates real problems when those folks are in accidents and hurt people.
And it hurts all of us because our uninsured motorist rates go up.
That's correct.
I just wondered.
Yes. In Virginia, you can register your vehicle without any insurance.
And has that changed? I thought that maybe that changed this year. That didn't change?
Well, I don't know if the Virginia Assembly changed it. I know they just adjourned sine die, but it is not current law.
It didn't change it?
Yeah.
It also, even if they required insurance, it probably would not meet the limits that we have in Maryland.
That's right.
So.
And as you indicated, that makes it more expensive for Maryland residents who are playing by the rules.
Thank you.
Thank you.
Thank you. Senator from District 5.
Thank you, Mr. President. And I agree that it certainly is a challenge, and I think it seems like the committee worked very hard to try to find the right balance. A couple of questions or concerns, if I could ask the floor leader.
Senator may proceed.
I appreciated the response on the enforcement, and it's not my neighbor seems to have a car in their driveway that has a out-of-state tag, because we don't want people getting in the middle of that, which is appropriate. A couple of questions. On page one maybe a minor question. On page 5 of the reprint, there's a reference to tag and titles being basically, as I read it, being forbidden from selling out-of-state tags to forbidden from advertising and offering for sale and selling to somebody that I assume, it doesn't say knowingly, but I assume it's if they know the person is a state resident and they sell them an out-of-state tag, that they can't do that, right? They're not supposed to do that already, but this just spells it out in the law?
That's correct. Under current law, they're not allowed to sell it. We added that they're not allowed to advertise for sale. If you spend 1 minute on YouTube, you'll see exactly what the chair mentioned. Hey, don't want to be covered by insurance? Hey, have 40 tickets and don't want to be held accountable? Come to us. Right. We'll hook you up in Virginia.
I assume the Tag and Title Association, if they registered any concern, you guys have dealt with that, or they didn't register any concern?
They didn't register any concerns.
Because they're concerned about these bad operators doing that too. They wouldn't want the reputable business. Okay, then that's good. But they're not, so it's not changing the law in any way other than it's saying you may not advertise now either. So
that's correct.
You already were really not allowed to, but it's just making clear. Okay.
Exactly.
But it does not touch, it sounds like, based on how I read the bill and the back and forth, it does not touch the trailer issue.
That's correct.
Which is good. Okay.
With thanks to the senator from Frederick for introducing that concept to us.
Yeah, farm implements and that sort of thing. Okay, that's great. On page 5, I noticed there was a change from the language of probable cause to reasonable cause. And while I am not an attorney, and I have a shirt from a judicial proceedings committee party from many years ago that says I'm not an attorney, so I know I'm not an attorney. What does that mean? Because I'm not sure I've heard of reasonable cause, or haven't seen it in our bills much.
Yeah.
What's the standard of reasonable versus probable?
Thank you. So that language came from MVA. Probable cause, as you know, is a term we use in criminal law. This is an administrative process unrelated to criminal law. It seemed out of place to use the phrase probable cause. Reasonable cause better reflects the administrative process that we're trying to achieve.
Do we have a way, and that does make sense because probable cause, there's a certain amount of evidentiary.
Sure.
But there does need to be some evidence that they're doing this. So is reasonable defined anywhere, or what? Did they give any input as to what they would view as reasonable?
So it's just the regular and customary vernacular that MVA uses in all their administrative proceedings. So it's not particularly new language. It basically is distinguishing between, any cause to something that you have to articulate and provide.
So if it's been flagged in the system as you're a in-state resident and you've purchased an out-of-state tag, that alone is reasonable cause, I guess, probably for them to issue this.
I would say so. That's correct.
But they can't just.
They can't do it willy-nilly.
Right. Okay. I guess one concern I have with this bill, probably the only real concern that I would say that I think my colleague talked about collections as being an issue, which I think is completely correct.
Absolutely.
But I've also, and I think we've all had constituents, and the head of the MVA is a great person who's worked very hard at that agency. She's been multiple administrations in both parties, and there's been a lot of improvement with MVA. But we all have constituents who will get letters. With this historic tag issue was something that happened where people were getting letters like they're already in violation by the time they get the letter. I remember as a young person getting a letter telling me my license had been suspended because I had not responded to something. At the time I lived where I had to use a P.O. box, the suspension letter came to the P.O. box, but the other thing didn't because they didn't mail that to P.O. boxes. And that was years ago, and it's just an anecdote. But we hear this from our constituents. So I guess my concern is that the 60-day count, you're going to get a summons, you're going to get a notification that you're in violation. What I don't want is for you got the letter and they say 60 days, but the letter's dated 45 days ago. Does that make sense? I mean, how can we be sure when we're giving it over to MVA or any sort of state agency, is it 60 days from the time the violation is discovered or 60 days from when you're notified, or what's the 60-day count?
Yeah, that's a great question. So line 29 says within 60 days after the issuance of the warning. And so I would read that to believe that when MVA sends the warning to you, that triggers the 60-day clock, not the time of violation.
How will is it going to be sent in some sort of certified manner? I mean, I'm imagining the answer to that is no, but how do we know that?
So, I mean, I see what you're saying. To my knowledge, there's no issue with people receiving these warnings
They're just ignoring them.
Distant from the time in which it was sent. I mean, for all intents and purposes, the 60 days will begin when you get the letter.
How do you, okay. How do you rectify, if you've been, let's say you're somebody who's done this,
Mm-hmm.
and we all agree you shouldn't, but somebody that's not overly is sophisticated and is just doing it because their buddy told them they could do it. Hypothetically, no, I'm kidding. It's not me. I'm joking. How do we make sure that how do they do this? How do they fix it? How do they go, oh, okay, you got me, or I didn't realize this? Do they just go register? Do they just go to their local MVA or even go online and pay the register? How does it work?
Yep. So this doesn't change that process. To get right under current law is the same way you get right under the new bill. You simply re-register your vehicle back in Maryland. But I'm glad you brought it up because someone trying to do the right thing, re-registering in Maryland, because you registered out of state, you would have a fee to re-register in Maryland, an excise tax. Because that person was originally registered in Maryland, we have now put in this specific legislation that we strike the excise tax and give immunity from the excise tax to re-register back in Maryland.
I think I saw that in the bill, and that is good. That's a good job by the committee. I appreciate that. And then I think maybe my last question here, I'm just trying to, the part about allowing the counties to do this enforcement, and I understand functionally we got to have help from the counties. It can't all be the MVA's enforcement. we changed from state's attorney to county attorney. That does mean the county, literally the county council or the county commissioner's attorney, the attorney for the county government?
Yeah, so in I think every jurisdiction is referred to as the county attorney.
Okay.
It's not the county attorney for the council or local governing.
It's for the county government's
That's-
attorney or team of attorneys, correct?
That's right. And in Baltimore City, it's the city solicitor, so same thing. The reason we changed it is because this is not a criminal process.
Right, and
it's
we don't
an
want
administrative process.
and we don't want to burden the state's attorneys with this either. So that's right, it's not criminal.
That's correct.
Okay, all right. I appreciate the answers. Thank you very much.
Thank you, Senator.
All right. On the bill, on the amendments, any further discussion? Any objection to the amendments? Without objection, the amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 111 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 310, Senator Jennings, Criminal Records, Maryland Judiciary Case Search, Track of Violation by a Minor, favorable.
Recognize the senator from District 4.
Thank you, Mr. President. This bill, like the last bill we just discussed, was unanimous in committee. In spite of, I hope we can all see that this is a very important bill in spite of the sponsor, and we can get past that together. But this bill, Senate Bill 310, will prohibit the Maryland Judiciary Case Search from referring in any way to the existence of records relating to an alleged violation of the Maryland vehicle law or any other traffic law, ordinance, or regulation by a minor. This is protecting our children. Mr. President, there are no committee amendments. I move the adoption of the favorable committee report.
All right, floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 310 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 352, Senator Charles, Motor Vehicles, Special Registration Plates, Old Line Plates, Old Line Plate Program Act of 2026, favorable with 3 amendments.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. As amended, this bill requires the Motor Vehicle Administration to develop and make available an old line registration plate for certain vehicles. An old line plate must resemble the registration plate issued by the state for display on a motor vehicle in 1911. The bill establishes requirements related to the issuance through auction and transfer of such plates. Amendment number 1 alters the title of the bill, adding license. Amendment number 2 is technical, and amendment number 3 alters the distribution of revenues from the program. I ask that we move on the amendments, adopt the amendments, and then pass the bill.
Floor leader moves for the adoption of the 3 committee amendments in the favorable committee report. On the amendments, any discussion? Any objection? Yes, I recognize the senator from the 28th on the amendments.
Yeah, thank you, Mr. President. This is a military day for me. Permission to ask the
please, Senator,
floor leader a question? Yeah, thank you. So with these old line plates, Senator, will there provisions to have the special military plates offered in Maryland, whether disabled veterans or, honor plate, to use the old line plates for those special military plates?
No, this has nothing to do with military plates. This is specific to a type of license plate that goes back to, like I said, it's 1911. So it has nothing to do with the military plates.
Yeah, I know. And okay, thank you for that answer. So someone, say, in the military might like an old line plate with a military designation. So I want to know if they would have that option of doing that with the old plates, old line plates.
Not with this bill.
Mr. President, could I lay this bill over for amendment?
Motion would be in order. The bill and the amendments will lay over under the rule.
Okay. Thank you.
All right. Clerk, read the next bill.
Senate Bill 698, Senator McCray, Vehicle Laws, Dangerous Accumulations of Snow and Ice, Removal from Exposed Vehicle Surfaces, favorable with 2 amendments.
Recognize the senator from Baltimore County as the floor leader.
Thank you, Mr. President. This bill, as amended, prohibits a person from operating or towing a vehicle without making reasonable efforts to remove any accumulated snow and
Excuse
ice.
me, Senators. Senators, please, if we could give our attention to the floor leader.
Thank you very much. that poses a threat to persons or property from exposed vehicle surfaces. A police officer may enforce a violation of this prohibition only as a secondary offense, except when the violation contributes to an accident resulting in the property damage, death, or serious bodily injury. There were 2 committee amendments. The first is technical. The second alters the prohibition that creates exceptions where compliance would result in a violation of safety laws or regulations or would endanger the safety of the vehicle operator and clarifies the effect of a continuing violation. The vote was unanimous, and I would move the amended committee report.
Of all the bills we do, I bet this is going to be the one people talk the most about, if I had to guess. All right, floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 698 is hereby ordered printed for 3rd reading. All right, let's stick with judicial proceedings. We are at report number 13. Clerk will read the first bill.
Senate Bill 8, Senator Hester, Criminal Law, Identity Fraud, Artificial Intelligence, and Deep Fake Representations, favorable with 2 amendments.
Recognize the chair of the committee as the floor leader.
Thank you very much, Mr. President. As amended, this bill expands prohibitions under the identity fraud statute, including prohibiting a person from using a personal identifying information to cause harm as specified and assuming the identity of another to harm, harass, intimidate, or threaten. The bill also prohibits a person from using artificial intelligence or deepfake representations for specified fraud-related purposes. Finally, the bill authorizes a person who is the victim of a specified prohibited act to bring a civil cause of action for injunctive relief or other appropriate relief against the person or persons who committed the act. It makes clarifying changes regarding related penalty provisions. Mr. President, there are 2 committee amendments. One adds sponsors to the bill, and amendment number 2 alters the prohibition under the bill. I'd move for the adoption of the 2 committee amendments and the favorable committee report.
Excuse me, senators, please. Can we all just please make sure that we're focused back there? Thank you. All right, floor leader moves the adoptions of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 8 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 162, Senator West, Criminal Procedure, Motion to Reduce Duration of Sentence, Repeal of Sentencing Date Limitation, favorable.
Recognize the senator, bill sponsor as the floor leader.
Thank you, Mr. President. This bill fixes an anomaly in the Juvenile Restoration Act. Under the current law, an individual who committed a crime when under 18 years old, who wishes to file a motion for sentence reduction under JRA after spending at least 20 years in prison, must have been sentenced for the offense before October 1st, 2021. But under the combined Juvenile Restoration Act and last year's Second Look Act, all other young people up to the age of 25 may seek a sentence reduction irrespective of when they were sentenced. So this bill removes the anomaly in the current law. There are no committee amendments. The vote of the committee was unanimous. I hereby move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 162 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 230, Senator West, Criminal Law, 3rd-degree sexual offense, burglary, favorable.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. Another anomaly bill. This bill establishes that it's a 3rd-degree sexual offense to engage in sexual contact with another person without the other person's consent in connection with a burglary in the 1st, 2nd, or 3rd degree. A person who conspires to, attempts to, or commits this offense is either a Tier 1 sex offender if the victim is not a minor, a Tier 2 sex offender if the victim is a minor who's at least 13 years old, or a Tier 3 sex offender if the victim is a minor who's younger than the age of 13. The bill will apply prospectively to acts committed on or after October 1st of this year. There are no committee amendments. The vote of the committee was unanimous. I hereby move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 230 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 365, Senator Waldstreicher, Security Guards Certification Renewal Requirements, favorable, 2 amendments.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. We went in previous years from a paper-based system to an electronic system when it comes to the recertification of security guards, but neglected to take out some of the old provisions related to the paper certification. This switches us completely to electronic certification and re-registration and cleans up the old law, excuse me. There are 2 committee amendments. Amendment number 1 is technical. Amendment number 2 restores language previously repealed under the bill as drafted. Mr. President, I move the 2 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 365 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 512, Senator Smith, Criminal Law, Stalking Penalties, favorable.
Recognizing the chair of the committee is the floor leader.
Thank you very much, Mr. President. This bill alters existing penalties for stalking if a person committed the act and either the person had an interim temporary or final protective order in effect against the person at the time of the offense in which the victim was a petitioner, or 2, the person had a court order in effect against the person at the time the offense prohibiting stalking involved the victim. The person who has a previous conviction in the state for stalking, or the person has a previous conviction under the laws of another state that would constitute a crime of stalking if committed in the state. A violator who engages in stalking under these circumstances is guilty of a felony. There are no committee amendments. The committee vote was unanimous. I'd move for the adoption of the favorable committee report.
All right. Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 512 is hereby ordered printed for 3rd reading. Sticking with judicial proceedings, calendar 14, report number 14. Clerk will read the first bill.
Senate Bill 42, Senator Simon Ayer, Reduction of Facilities in Veteran Service Organizations, Hydrolyzed and Soil Remains, Immunity, favorable.
Recognize the senator from District 1 as the floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 42, Veterans Cremation Revisions. Colleagues, recently Maryland updated its burial laws to allow the addition of cremains in use of hydrolyzed remains and soil remains. The bill just simply updates the laws dealing with unclaimed veterans remains that are transferred and received by including unclaimed hydrolyzed or soil remains in veterans language. There are no amendments, and therefore, Mr. President, I move the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 42 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 471, Chair, Judicial Proceedings, Circuit Court Clerks and Registers of Wills, Maximum Salary, favorable.
Recognize the senator from the 16th District as the floor leader.
Thank you, Mr. President. This bill alters the maximum annual salary that the Board of Public Works may set for the clerk of each circuit court and a register of wills from $146,000 to the salary of a state employee at grade 26, step 20 of the State of Maryland Standard and Bargaining Salary Scale. The bill also repeals an obsolete provision establishing a minimum annual salary of $12,000 for the Register of Wills in Baltimore City. Pursuant to constitutional requirements, the salary increases for the clerks of the Circuit Court and the Register of Wills take effect at the beginning of the next term of office. There are no amendments, and this was a unanimous vote out of the committee. I move the favorable report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 471 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 477, Senator McKay, Civil Actions, Real Estate Appraisals, Statute of Limitations, favorable with 2 amendments.
Recognizing the bill sponsor is the floor leader.
Thank you, Mr. President. Senate Bill 477. This bill is subject to specified exceptions establishing the statute of limitations for civil actions for damages against a person for an alleged act or omission related to the performance, review, supervision, and management of real estate appraisals, regardless of whether the appraisal is in the connection with a federally related transaction. A civil action which which the bill applies must be filled within an earlier of 2 years after the date of complainant knew or reasonably knew or known the act or omission, or 4 years after the date when the performance review, supervision, and management of the appraisal as applicable was provided and should be provided. The bill applies prospectively only and may not be applied or interpreted to have any effect on any application and causing of action occurring before the bill's October 1st, 2026 effective date. Mr. President, there are 2 amendments. Number 1 is technical. Amendment number 2, colleagues, extends from 5 to 12 years the retention period for appraisal reports and all supporting data that an appraiser assembles or formulates to prepare an appraisal report, and extends from 2 to 12 years the limitation period for civil actions alleging discriminatory housing practices related to the appraisal of a residential real estate property. I hereby move, Mr. President, the adoption of the favorable committee report with 2 amendments.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 477 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 573, Charles County Senators, Charles County Governing Bodies of Common Ownership Communities, Member Training, favorable.
Recognizing the senator from the capital city is the floor leader.
Thank you, Mr. President. This bill requires, in Charles County only, each member of a board of directors or officers of a council of unit owners of condominiums, that each member of the governing body of a homeowners association as well, to successfully complete a training curriculum on the responsibilities of being a member or an officer within a specified time frame. There are no committee amendments and the vote was unanimous. Move for adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 573 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 694, Senator Smith, Human Relations Violations of County Discrimination Laws, complaints, favorable.
Recognizing chair of the committee is the floor leader.
Thank you very much, Mr. President. This bill establishes that filing a complaint with the Maryland Commission on Civil Rights satisfied specified prerequisites to commencing a civil action alleging a violation of discriminatory or prohibited acts by a county code in Baltimore, Howard, Montgomery, or Prince George's counties. There are no committee amendments. The committee vote was unanimous. I move for the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 694 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 758, Senator Watson, Common Ownership Communities Candidate or Proposition Signs Display Period, favorable.
Interesting. Bless you. Senator from the 26th District is recognized as the floor leader.
Thank you very much, Mr. President. And members of the Senate, this emergency bill alters statutory provisions authorizing a cooperative housing corporation, condominium, or homeowners association, referred to as COCs, to regulate the display of candidate or proposition signs by limiting the display of signs to a specified time period. Subject to existing provisions, the bill authorizes COCs to limit the display to a period beginning no earlier than 45 days before start of early voting. If early voting is not conducted no earlier than 45 days before the primary general election, or vote on a proposition. This bill passed our committee unanimously, and so I offer this bill and ask for a favorable report.
All right, floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any further amendments, or are there any amendments to the bill or its title? Seeing none, Senate Bill 758 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 760, Senator Watson, Real Property, Recordation, and Land Records, revisions favorable.
Recognize the senator from the 25th as the floor leader.
Thank you, Mr. President. This bill, number one, repeals a requirement that a printed deed or other instrument offered for recordation include certain margins, and two, requires a clerk of the circuit court to date each change or correction made to information in the general alphabetical index on the horizontal line of which the change or correction was made. There are no amendments, and I move for a favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 760 is hereby ordered printed for third reading. We still have some JPR items here. This is Special Order Calendar 34. Let's see if we're ready for this. Clerk will read the bill.
Senate Bill 463, Senator Muse, Municipalities, Vagrancy, Repeal of Authority to Prohibit. Bill is on second reading and open to amendment.
Recognizes the bill sponsor.
Thank you very much, Mr. President. I would ask that this would be special ordered until Monday so that we can get with the others to try and work this out. Also, permission to use Senator's name. We really want to win over Senator Folden. I bought new socks for him today. I think it should do it. I thank you very much.
All right. Any objections to the Senator's special order, motion to special order? Without objection, the bill will be special ordered at the appropriate time on Monday. All right. All right. I think that does it for judicial proceedings. Let's go to education, energy, and the environment. We'll start with report number 12. Clerk will read the first bill.
Senate Bill 31, Senator Lamb, School Construction and Housing, School Zones, Adequate Public Facilities Ordinances, favorable with 3 amendments.
Recognize the Vice Chair of the Committee as the floor leader.
Thank you, Mr. President. Colleagues, there are 14 counties and 34 municipalities that have APFO laws. That's Adequate Public Facilities Ordinance. And what that means is before building, whether that's schools or communities, we want to make sure that there is sufficient sewers and roadways and all the amenities in order to make sure that that goes successfully. This bill just says that during the period of consideration by an APFO process that a community could move forward, that a developer who wants to build a new community because we need housing in Maryland, that they can start having conversations, moving things forward with permitting, and then once things are ready to go, then they can move forward in a more efficient way. So this bill simply does that, and there are 3 amendments. The first was technical. The second one makes sure that that data from municipalities are included in the annual report to the interagency construction board and making sure that they've got that. And the third one clarifies that the prohibitions for delaying the process in the subdivision development plans only apply to APFOs and that include a definite maximum length. There's some that have no end purpose. So I move adoption of the amendments and the favorable committee report.
Floor leader moves to the adoption of the 3 committee amendments and the favorable committee report. Recognizing the senator from Montgomery County.
Thank you, Mr. President. Would the floor leader mind yielding for a couple of questions?
Senator may proceed.
So this applies to the school portion of an APFO exclusively, not other things like traffic counts and whether there's road capacity or
Correct.
sewer capacity.
So APFOs cover all of that, but as we've seen in Montgomery County and many places around the state, we need the data before we start deciding whether to build schools, expand schools, close schools. And so we need that data. But in the meantime, we need to build affordable housing or any housing. And so the APFO process helps make sure that the counties and the municipalities are ready to go But in the meantime, there can be behind the scenes progress so that once they're out of what the sponsor calls APFO jail, once the waiting period is over, that things can be moving forward apace.
So, for instance, Montgomery County's had, adequate public facilities ordinances, requirements for decades. Does this affect specifically local jurisdictions in how they will operate their APFO? And again, it just is specific to whether school capacity,
So,
not anything else.
Does sponsor want to clarify that one?
Will the floor leader
yield to the sponsor of the bill?
Yeah, sure. It is really just, so local jurisdictions that have APFO or APFO, those would still be in place. All it allows is that folks that may be interested in proposing development, for them to be able to go to the county to at least start the pre-permitting and the review process. It doesn't shorten that APFO period at all. But
so
once
it
that
is
period
applicable to local governments. In other words, this would apply, and I'm not taking issue with the concept. It sounds like the goal is to help facilitate and expedite development process during the APFO. But does it limit it to strictly school capacity, or is this also just entirely the entire process?
The entire process back to the county. So the county may have APFO requirements for schools, for utilities, for transportation needs, highways, roads, and the like. It doesn't alter that process for the county. It just says that while the county may have a delay, while those types of components
some of the other
catch up.
process says other processes continue to move forward.
Correct.
Perfect. Thank you for the explanation.
Sure.
Thank you. Thank you, Mr. President.
Thank you, Senator. All right, on the three amendments, recognize the minority leader on the amendments.
Thank you, Mr. President. The floor leader would yield, please.
Floor yield. Senator may proceed.
Sure.
Okay, thank you. I noticed that MACO had opposition to this legislation, and they said specifically that this could create new obstacles in approving housing stock rather than accelerating it. Did the amendments address MACO's concerns?
My understanding, and my understanding is that many of their concerns were addressed. I don't think MACO loves this bill, but this is about making sure that the Interagency Committee for School Construction has the data in a timely way. Senator?
Senator, yield to
yeah, I'll yield to the sponsor of the bill.
Yeah, so the MACO was concerned because there are some counties where the delay is indefinite. So, there are some counties where they'll say that to meet adequate public facilities ordinances, there's a delay of 4 years, there may be a delay of 6 years, while each of these components catch up. There are some counties where the delay is indefinite. And so what we did in this bill through the amendment was for those counties where the delay is indefinite, they're not required, this doesn't apply to them because there's no point in having a developer go through the pre-permitting, the review process with that local jurisdiction if the delay is indefinite. This only applies via this, as amended, would only apply to counties where there's a set time frame for the delay. So it addresses that main concern that they
And that's what most counties do? They set a time frame on how long this process will take?
I think it's only a minority. It's not all 23 counties that have APFO requirements.
Right.
It's only a minority of those counties, and so 14 of the, I guess that is a majority, 14 of the 23 counties have APFO ordinances, but a lot of them have an indefinite hold for APFO. And so this bill would not apply to them because there's no point in having anyone go through a county process for APFO review if the delay is indefinite. This is only applicable where counties have a set time period for the delay because there's an end in sight for when that time period would expire.
But does this bill now, as amended, address MACO's concerns? That
We believe
that
it
it's
should
not
address
creating
most of
obstacles?
MACO's concerns, yes.
It does, okay. All right, thank you very much. Thank you. Thank you, Mr. President.
Thank you, Senator. All right, recognize the senator from the 28th District.
Yeah, thank you, Mr. President. I'm not sure if I should ask the floor leader or the bill sponsor the question, but let me start with the floor leader. Is that okay?
Well, the floor leader, Senator may proceed.
Of course.
Yeah, thank you, Mr. President. So, adequate public facilities. So just looking at the title of this bill, it's talking about construction, school construction, housing, school zones, and adequate facilities. So there's an issue in Maryland where a majority of our jurisdictions don't have sidewalks for kids to get from their housing area to the school. And other members have addressed that issue over the years. And believe it or not, it is such a huge problem, no one want to deal with it. Montgomery County says, hey, solving that problem, providing adequate sidewalks will take close to $90 million to do that. Baltimore County, most of the counties went in and basically said that. And I've worked with Charles County over the years and working with MDOT to kind of fix that problem, because there's a school in Charles County, Thomas Stone High School, where there are absolutely no sidewalks going from the school to the housing area. Absolutely no sidewalks. So the kids have to walk on the grass, and it snows, they walk on the street. And we're like, well, I'm like, how could we as a society put up with that? Such a visible, unsafe issue. And so we've tried to address that over the years, because there are huge problems through the years here in Maryland. So my question is, adequate public facilities connecting schools, school zones, and schools. Is sidewalks included in an adequate public facility definition?
Senator, you've been a leader on sidewalks, and I should have expected that you'd be asking about that. So thank you for the question.
I'm happy to please.
There we go. So as I mentioned earlier, just 14 of our 23 counties in Baltimore City have adequate public facilities ordinance laws, and another 34 municipalities. So they have their independent authority to decide what the adequate facilities must include. I'm not sure whether sidewalks is included in that. And so that's where the work we do in this body is helpful and informative, but frankly, the county council, county commissioners, mayors and councils can focus on things like sidewalks. But this is about sewer, traffic, roadways, making sure that people can get to the school, that the community can flourish and succeed.
So get into the school. So most kids, or maybe a few seniors drive and can drive and have the money to drive cars. But if they live close enough to the school, they have to walk. So I'm really surprised that we're not sure if sidewalks is part of this adequate public facility. I mean, how do we consider our children? I know they don't vote at the same time, right? If you talk about driving on cars being adequate, connecting homes with schools and safe zones to schools, I think, correct me if I'm wrong, as far as shouldn't sidewalks be in this?
Senator, you make a valid point, but that's not what this bill does.
Well, the question is, should it? I mean, if we're talking about adequate facilities, this has been looked over so many years by our governments in Maryland, right? And so it's in the bill testament from the counties and someone mentioned Mako earlier, really vigorously oppose creating safe pathways to schools. And when there are public funds from the federal government available through Maryland Department of Transportation to build those sidewalks, I mean, why is the problem still there? Why is it not included in adequate public facilities when we talk about housing and communities and school zones? I'm not sure why we didn't address that in this bill.
In this bill, none of the specifics are included. This is a process bill and not a mandate on what counties or municipalities must consider during their own process with an APFO process.
So I'm sorry.
Thank you for the question, but that's not what this bill does.
Okay, so maybe I could ask the bill sponsor, Mr. President. Okay.
You have the sponsor?
Sure.
Yeah. So what does this bill does if it doesn't take care of something like, a sidewalk? We talk about roads, we talk about schools, we talk about housing, but we leave out sidewalks where children have to navigate.
Yeah, so the bill has two main provisions. And I think because of the title, there's some things that are being brought together that are not necessarily, a nexus in this bill. The bill has a requirement where local jurisdictions are supposed to report up to the Interagency on School Construction, the IAC, on school attendance, so that the IAC will have better data to be able to decide how to designate funding for different schools across the state. The bill also includes a provision to say that for development to be considered, that when a county has an adequate public facilities ordinance in place, there's a delay, that those developers can at least start working through the pre-permitting and review process and mapping and those kinds of, processes while the delay is going on. Just to be clear, APFO is not specific just to schools, right? So schools are one component of what a local jurisdiction would look at for APFO. There are roads, there are utility issues, there may be landscaping and surveying issues that need to take place as part of adequate public facilities ordinances. Schools are only one part of the facilities that they would be looking at. Obviously a very important part, but what is designated as part of APFO locally is really deferred up to the locals, the county commissioners or the county council, county executive.
Yeah. And so, yeah, thank you for that answer. And so basically, the title, we're talking about schools and construction and housing, school zones, basically would lead one to think that we address the holistic issue there.
Yeah.
And so, I mean, as a body, why don't we address this major gap in safety in Maryland? Because every year I've heard about children being run over going to school, right? I've heard about, and we all hear about these unsafe zones. And last year, I was driving home. I started to cry. I heard on WTOP radio. Whoops, maybe I shouldn't say that. Okay, sorry, Mr. President. But I don't want to promote WTOP radio. But a child got run over in Montgomery County going home from school, and the county leaders said, hey, we have to come now and study safe pathways to school. Why do we react after it happens? And we pass in these bills that say a title like this, and we don't have that particular in it, sidewalks. I just want to understand why we cannot include. So we'll be able to include sidewalks in this bill since it was left out. Maybe that's a question for the floor leader.
The 14 counties and 34 municipalities have the authority to decide what is covered in their adequate public facilities ordinance as they are preparing for development and for school expansion. And that's what this bill does, is make sure that the data is accurate so that when schools are built, closed, or expanded, that the data is there from both the counties and now with this bill with the 34 municipalities as well, that data is going to be included.
Yeah, and my question is, can we include sidewalks? I'm sorry, I didn't mean to cut you off.
No, thank you, Senator. It's not in this bill, but it's a conversation that you could have, and sadly you won't be able to do that next year, but maybe you can find a senator to sponsor that bill in the future.
Will you be able to do that, Senator? That commitment. Well, thank you, Mr. President. I guess that's an inappropriate question.
All right. All
Thank
set?
you, Mr. President.
All right, thank you, Senator. All right, question remains on the 3 committee amendments. Any further discussion? Any objections? Without objection, the 3 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the favorable committee report as amended is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 31 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 54, Senator Lamb, State Board of Veterinary Medical Examiners, grounds for disciplinary action, restrictions, favorable.
Recognizing Chair of the Committee.
Thank you, Mr. President. Senate Bill 54 prohibits the State Board of Veterinary Medical Examiners from suspending or revoking a license to practice veterinary medicine in the state, reprimanding or censuring a licensee, or placing a licensee on probation solely on the basis of the licensee discussing or recommending the use of a cannabis product that contains cannabinoid CBD to a pet owner for the animal for potential therapeutic effect for health or health supplementation purposes. There was no opposition at the bill hearing. The bill passed unanimously, Mr. President. I would move the favorable committee report on Senate Bill 54.
I was wrong. I think this is the bill that will get discussed the most after. All right. Any senators move for the adoption of the favorable committee report? Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 54 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 301, Senator Simon Ayer, Veterans Discounts Act, favorable with one amendment.
Mr. President.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. This bill authorizes but does not require specified government entities to waive fees for certain licenses, registrations, applications, or renewals for a veteran. Before a fee waiver may be granted, the relevant entity must adopt regulations to allow these waived fees. There was one amendment that had co-sponsors. This passed Triple E and Finance unanimously. I move the amendment and the favorable committee report.
Floor leader moves to the adoption of the one committee amendment and the favorable committee report. On the amendment, any discussion? Any objections? Without objection, the one committee amendment is adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 301 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 325, Senator Augustine, Land Use Permitting Development Rights, Maryland Housing Certainty Act, favorable with three amendments.
Recognize the chair of the committee as the floor leader.
Yeah, thank you, Mr. President. Just a little context. This is a very important bill, and just a little background. There's been a great deal written and discussed about Maryland's housing affordability crisis and the current shortage of about 100,000 housing units to meet the demand and growth projections in our state. For our residents, and this problem has been particularly causing, in some cases, our younger individuals, middle-income families to leave the state. So in October of last year, Comptroller Lehrman released a very, very comprehensive report on this topic, and one of the biggest issues, Mr. President, identified in that report is the need for our state to have more regulatory certainty, particularly when you compare how things are done in some of our neighboring jurisdictions who are permitting far more housing units. And so as a developer, in terms of attracting investment, it is critical that you know the laws and the rules of the road on the front end when it comes to laws and regulations governing zoning, permitting, et cetera, and the prospect that those laws and regs can be changed years after the project gets started is highly problematic. And so Senate Bill 325, the Maryland Housing Certainty Act, attempts to tackle this crisis in two very thoughtful ways, and I want to commend the President Pro Tem for introducing this bill. And so what Senate Bill 325 does, it establishes first that a housing development project application approval or denial is governed only by laws and regulations in effect when a complete application was submitted, and after approval, the proponent of the project has a vested right to the authorized use and development for the longer of 5 years or a period determined by the local jurisdiction or the local jurisdiction. Currently, Mr. President, Maryland, we have a very late vesting right. We're a very late vesting right state relative to our neighbors, and we need to remove that regulatory uncertainty. So the bill also prohibits a county or municipality from collecting development impact fees or excise taxes imposed on a residential real estate project until after the construction is complete and all requirements for a certificate of occupancy, occupancy permit, or other equivalents have been met, which is the impact fees will go in closer to when the impacts are really occurring, for example, school capacity and things of that nature. So when you take these two things together, the two components of this bill, these changes really will have the impact of reducing the cost of developing residential projects in the state of Maryland, which is sorely needed. Mr. President, we have three committee amendments. Amendment number 1 is technical. Amendment number 2 applies the bill's regulatory certainty provisions to complete rather than substantially complete to a complete applications and extends the timeline for local jurisdictions to make a determination regarding the completeness of an application. Amendment number 3 strikes references to surcharges and provisions concerning the collection of development excise taxes and impact fees. The amendment also authorizes local jurisdictions to collect these taxes and fees as a precondition to conducting a final inspection, but not more than 30 days before the date of the inspection. So with that, Mr. President, I'd move the three committee amendments and the favorable committee report on Senate Bill 325.
All right, floor leader moves to the adoption of the three committee amendments and the favorable committee report. On the amendments, and the report recognize the minority leader.
Thank you, Mr. President. The floor leader would yield.
Senator may proceed.
Yes, sir.
Thank you very much for your explanation, but can you explain vested rights?
It's the point at which, you know, as I said at the outset, one of the issues is when you're starting to develop, you need to know what the laws in effect at that time are, and are they going to last to a point where they may be subject to change. And in this case, your vested rights kick in. I think it's when here, let me just be very specific about when that happens, but it's your legal right to rely on the laws and regulations and ordinances in effect when you're trying to pencil out the project and project the project. The problem in Maryland is we are currently a late vesting state, and therefore you don't have the certainty doesn't kick in until much later in the process, so you're subject to having the rules of the road changed in the middle of the project. And so that adds costs. I mean, if you're thinking about regulatory certainty, we always talk about that. That projects uncertainty into a project and ultimately increases the cost of a project and ultimately the cost of a housing unit on the front end, and when it's financing and all the rest that goes into a project at the beginning. So
obviously this is very important for the developers of the projects to recognize that, and not to make joke of what we just talked about, but you're right, the General Assembly could pass a bill that said sidewalks are required at a certain types of developments and things like that. If you had your application in prior to that, is what you're saying you'd have the vested rights, you would not then have to be subject to the new rules that came in since you first submitted? Is that right?
Yeah, only when the plan is, once the plan is approved, then again, there's a 5-year, you vest your rights for 5 years thereafter. And the other point I think that's very significant is looking at other jurisdictions. I'll just, if I might, Mr. President, name a few jurisdictions that have early vesting rights at Delaware and Virginia and they're doing a better job on producing more residential housing units. So yes, so it's upon approval, and then for 5 years, you can rely on that certainty as you plan the project, the development.
So again, I think that's very positive for the developers. Was there any opposition to that at all? I mean, would somebody think that that's not a good idea to have those vested rights for 5 years?
I mean, my recollection, I'll get confirmation, I think the early vesting right for those who are building these projects is a huge improvement over the current situation in our state. And the other part of it is providing a framework for certainty from a statewide perspective, because right now you have a hodgepodge, I believe. Okay, there was 2 of our 23 jurisdictions had some issues with the early vesting. The vast majority of builders and counties, I would just say everybody in this industry, for the most part, this is again a pretty significant improvement. And there was a lot of testimony about what's happening in Virginia, Delaware, and if only Maryland could again put that kind of certainty in place, there would be. But I think it provides a framework from county to county where you may have some different rules of the road, and this is providing some consistency from a statewide perspective as well.
All right, I was going to ask about county to county because I see that it talks about whether the different rules apply to charter counties, code counties, commissioner counties when it comes to when the development excise tax and impact fees are collected.
Yeah, this is statewide. Well, there's 2 different issues. You've got the early vesting rights part of statewide. The issue of the impact fees is a second part of the bill, which is also important because by delaying, this is also to incentivize that you've got carrying costs, you've got to finance on the front end. The fact that you can delay making that payment until closer to when the impacts and when the project is complete, that also saves money. And I think and I could yield to the Senate sponsor, but I do believe it was something like $5,000–6,000 per housing unit just by the not having to finance on the front end, and the impact fees and all the rest come in much later when you've got school capacity issues and the like, and so that's a separate part of separate component of the bill, but also ultimately reducing the cost of housing units.
Right, and I do agree with that. I think Finance Committee heard a bill that had some, I don't know if it's the same bill or not, but it had some similar attributes to this as well, with the collection of the impact fees and the development fees. And I think, obviously, from the developer standpoint, obviously this is very positive, that they're not having to front those costs and carry those costs all during the development, construction, and occupancy phase, that they can pay it once the C of O is delivered. But MACO, and I think the municipalities, had some opposition to that, claiming that sometimes they are forced to make infrastructure changes prior to getting to occupancy. How did that conversation go with them, and did it bring them on board with this bill, or did they still maintain their opposition?
Yeah, I mean, I think MACO, they're favorable with the amendments, and I think they, not shockingly, want the money quicker.
Right.
But the reality is, and I think the sponsor was asked this question very specifically, and if Senator wants to weigh in on this, is the vast majority. First of all, some of those earlier, I would say, infrastructure needs are actually picked up by the developer, not the county government. And the impacts that we're talking about here, whether it's school capacity or the like, which are, would be a county, that's when the people are actually moving in. And so there might be some costs along the way, but the vast majority, when you start talking about impact fees in the area, are going to be when the folks are actually moving into the property, not along the way when there might be some developer picking up some infrastructure. I think this was a back and forth with, a back and forth with the sponsor, but so I think they want the money earlier.
Yeah.
Okay,
No,
I mean, I don't think that's, again, any great shock, but that our job here is to try to get more housing units built at a lower cost to address our affordability crisis, which, again, as I mentioned, is causing some of our young folks and families to leave our state, lower and middle income people to leave the state. So our interests may not be 100% aligned with counties wanting to get the money quicker.
Yeah. No, and I understand. I think they said the same type of thing. They talked about potentially having to increase fire and safety types of things, but you're right, those really didn't need to take place until occupancy actually occurred.
Correct.
But they did talk a little bit about some infrastructure, and I would assume that's some of the infrastructure that the developer is not, being responsible for. One of the comments was made that if they did move forward with some of the infrastructure and then the project didn't move forward, did that get addressed as far as, is there any
I think that's in
recourse
the,
back
that
to
is
the
in the bill.
developer?
I'll yield to the sponsor. I think there's the ability to back out. Here, I'll yield to the sponsor on that one. That did come up, and I do believe it's actually addressed in the bill.
Yeah, no doubt about that. So there is a couple different things. One, this bill doesn't change the authority of the local jurisdiction. It doesn't take that away in any way, nor does it take away any requirements for a development that may have requirements. That being those needs for the infrastructure that will be required for the delivery of the development. Like, you still have to do that. So you still would have to, if you need to upgrade the roads, or if you need to put in a signal, those types of things, you have to do that before you're able to deliver that, and that has to therefore be paid for by the entity or the individuals who are doing the development. All that this is looking at is this very special group of charges that are there, which we agree with. It doesn't take away the ability for the locals to do it, but for these that are for the things that would require like larger sort of changes to the larger infrastructure, things like schools, things like fire. But those things, as has been discussed, are obviously they're bigger, but they don't start to actually come online until that the development is actually starting to get utilized, because that's what it's about. I mean, that's the nature of the impact fee. It's the impact. But the impact is the people and the needs of the development. So if it's not there yet, then those are the fees that we're trying to say, let's just move those much closer to the delivery when you're going to start to need them. But the other pieces are not, I mean, you're still able to do everything that you need to do as it relates to a particular development. That's the way it works.
Okay, and I appreciate that response. And I noticed this also applies to both residential and mixed use projects.
That is correct.
And so is the pushing off of the impact fees and the excise tax for the commercial portion of this the same?
If it were in a
well
mixed
too?
use development project, then it would apply.
It would apply for everything.
Correct.
Okay, well, thank you very much, Mr.
Sure.
Sponsor. Thank you, Mr. Chairman.
All right. The question remains on the 3 amendments. Recognize the Senator from Baltimore City and County.
Thank you. Thank you, Mr. Chair. Again, I'm just catching up
Question.
here. Didn't have an opportunity to hear the bill or be a part of it.
Okay.
And as usual, my concerns are around the environmental requirements. And you know, before I was, it was my understanding that there would be some reference or assurance around environmental, the environmental components. In particular, I guess I want to ask about the definition of a complete application, and including materials and information required for the processing. One might have a complete so the definition of an application, would it include requirements for storm drain, forest buffer, all of those things? Currently, that's not defined, you know, as that, as a part of a substantive review.
Are you asking a question? Or
No,
what's your question?
I'm asking, does that include that, and where in the bill or elsewhere?
Okay, well, the
Clear
bill
that that's what's
varies.
part of the
Okay, the bill defines complete application. It's
Right.
it's right in the bill. I'm looking at the reprint. Means a housing development project application that includes all materials and information required for processing and substantive review as determined by the commission or the local regulatory authority, but may contain non-substantive errors, omissions, or similar inconsequential deficiency. So, I mean, whatever the current set of regime is on environmental, this bill is not addressing that. This bill is about trying to remove regulatory uncertainty,
Right.
get housing units built, and the complete application as defined here would still entail all the things that are currently required to build a project along those lines.
I understand, Mr. President, I understand the intent. Administrative review is a different process, a different office than an environmental review. And so, in other words, the way this works at the local level is that developers are able to present an idea of how something might work. And the idea does not necessarily address all the actual aspects of a site. And so once there's an application, if the application is complete, with this regime, my concern is that if the application is deemed complete, and therefore if something on the site is discovered in the process of actually applying for and getting the approval, what happens if it's determined that the site has issues associated with it that were not disclosed as a part of an application or reviewed?
Okay. First of all, what
And
the
again,
laws and
just give me a little
regulations,
grace, I wasn't here. Yeah,
the laws and regulations in place currently are unaltered by this bill. So whatever issues you may have concerns about the application process, the approval process, that is something you should take up with your local governments or whoever.
Just a reminder, Senator, to please, the senator, if we could refer from using.
What did I refer?
The senator's concerns.
Yeah, the senator's concerns. The senator's concerns should be addressed to the appropriate local folks, because this bill does not alter what's in current law at the local level for that process. My apologies, Mr. President.
Again, Mr. President, it's my understanding that any of our concerns about any bill, as a senator, we're able to discuss in this open forum, and we should be allowed to do that. The concern at the local level, this is state law. One of the things that happens at the local level is that on a regular basis, variances are issued to state law in order to facilitate compliance. Additionally, there is not a review. The permitting process does not actually, just the language of materials and information does not take into account a requirement to also address any kind of environmental impacts. I would like an opportunity, or I can do it after you pass the bill or in the House, but I do believe that we need some stronger, very specific language ensuring that the current practice, which is basically to give, if any developer says, well, you know, the stormwater management will make the project cost more. Like to do actually what is required under our current state law, says, well, it'll cost me more, or it'll take a lot of time. And so the local jurisdiction gives them a variance, to this process. I believe that already is happening. So if we do the research and look, our environmental laws basically are non-existent at the local level because of the use of variances. Given this effort to further increase and facilitate the ability to move quickly and to in some way limit the ability of communities or even our own agencies to be able to, if something comes up later, to be able to require additional work. I'm not talking about, aesthetics or anything, but something in, flooding or any of those other types of impacts. So, not quite sure what I'm doing here. I guess we can continue to go on with second reader. And Mr. President, I'll decide if I want to hold for an amendment. Maybe I'll chat with my chair a little bit, or if we can be promised that we can spend time, if the House bill comes out, to really look at this and come to some really a good way to ensure that our communities that are currently disproportionately impacted when it comes to the production of affordable housing, that the laws that we have set up in the range of environmental justice or cumulative impact are not, on the local, are not weakened.
Mr. President, just very briefly, there is a House bill, and if the House bill, comes over, we can, and I know you're back now, and obviously be clearly an opportunity to have some further conversation. Thank you, Mr. President.
Okay, thank you, Senator. Any further discussion of the amendments? Any objection to the amendments? Without objection, the 3 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 325 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 423, Senator Kramer, Research Facilities and Testing Facilities that use animals, Prohibition and Adoption Requirements, Animal Research Modernization Best Practices Act of 2026, favorable with 3 amendments.
Recognize the Vice Chair of the Committee as the floor leader.
Thank you, Mr. President. This bill, as amended, encourages testing labs to look for non-animal processes when they're doing research. We want to protect our dogs and cats, and it has been found that about 90% of the drugs that have been formulated based on animal testing don't work when they get transferred to humans. And so when the FDA or other agency approves an alternative testing method, that's what we want to encourage the use of. It'll have better results for human impact. It exempts vaccines and drugs, and this bill, as amended, also makes sure that there is confidentiality, but in terms of which lab, but annual report, and again continues the good senator's encouragement for adoption of animals that can bring happy homes. This is 3 things. It's about responsibility. It's about reduction in the number of animals used in testing, and responsibility and transparency. There were 3 amendments. The first broadly exempts medical research from the bill's restrictions on the use of traditional animal test method. Amendment 2 alters the rules around euthanasia to make sure that if an animal needs to be put down, it's done in the most humane way possible. And Amendment number 3 clarifies the application of the bill's reporting requirement. They do annual reports to the Department of Agriculture, so there is good transparency and accountability. With that, Mr. President, I move the adoption of the 3 committee amendments in the favorable committee report.
All right, floor leader moves for the adoption of the 3 committee amendments in the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 3 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 423 is hereby ordered printed for 3rd reading. Clerk, read the next bill.
Senate Bill 719, Senator Love, sewage sludge, per and polyfluoroalkyl substances regulation, favorable with 2 amendments.
Well done, Madam Clerk. Recognize the senator from District 8 as the floor leader.
District 9. It's
Sorry.
that time of day. No worries at all.
I was stuck on polyfluoro. That.
You mean perfluorooctane sulfonic acid and perfluorooctanic acid.
Precisely. Thank you,
Exactly.
Senator. Thank you.
Thank you all very much. So in plain terms, what this bill does, it's really the next chapter in cleaning up these forever chemicals. PFAS and PFOA have been linked to cancer and to development issues and all kinds of health impacts. And what we're trying to do is limit the spreading of these chemicals on our agricultural land so that we protect our farms, protect our farmers, protect our food, and protect our families. The bill passed unanimously out of committee. It establishes prohibitions and restrictions related to the land application of sewage sludge that has a total concentration of regulated PFAS equal or greater to specified levels. It requires the Department of the Environment and sewage sludge generators with certain requirements, and it establishes provisions related to the pre-treatment standards of discharge permits for certain industrial users. There are 2 committee amendments. The first one is technical. The second one delays the date on which the bill's land application restrictions take effect until October of 2028. It clarifies the rules around commingling of sewage sludge. It extends the timeline for implementing certain mitigation plans, and it alters the rules for PFAS testing. It also alters requirements regarding to assistance to publicly owned treatment works that do not yet have industrial pre-treatment programs. Once again, this bill passed unanimously. I urge the adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report, recognizing the minority whip.
Thank you, Mr. President. I wonder if I could ask the floor leader a question.
Senator may proceed.
We worked on this issue of sludge a couple years ago. In fact, the bill sponsor and I did. And is this the same kind of? Is this making a type of sludge illegal, or it's trying to regulate whether you're putting PFAS-related items into the sludge? Just confirming. I'm looking through the bill. It's regulating. I guess I'm asking to explain the commingling part of this bill. What are we doing? We're not making sludge illegal. We're not outlawing it. Are we changing how much you're allowed to put down, or are we changing what's allowed to be mingled into it with the bill, or both?
That is a great question, Senator, and I appreciate your leadership on this very important issue. We're talking about the sludge as it comes out of the municipal wastewater treatment plants. And so we are looking specifically at any sludge that is above 50 parts per million of regulated PFAS or between 25 and 50 parts per billion. If it is above 50 parts per billion, then they have to do a certain kind of treatment plan, and you cannot apply it after the date in the bill. If it's between 25 and 50, then you're allowed to commingle it with other things so as to bring that concentration down. And then once that concentration is brought down, there's a certain time period where you're allowed to apply it as commingled, but you have to continue testing. There's a lot of other technical stuff around there, but does that answer your question?
I think so. And then on the standard for the parts per billion, a few years ago, the federal government made it a lot. They made the PFAS concentration. Did they increased it for drinking water to parts per trillion, correct? Do you remember that? I'm just asking, I'm making sure we're not like being unreasonable in the level of, I don't want PFAS mixed in what we're growing. I'm just trying to, there was a bit of controversy about, like now all of a sudden, if you have even the tiniest traces, almost no trace, they're still saying it can't be in drinking water, which has led to a bunch of mitigation and remediation costs for local government. So I'm just trying to understand.
Yeah, the federal government does not regulate PFAS and sewage sludge. I believe
Okay.
what you're remembering and I'm trying to remember is like in 2025 there were draft EPA guidance for drinking water.
Right.
But this is not about drinking water. This is about
It's
sewage
about
sludge.
Yeah. Okay. Because obviously this is a much higher concentration that would be allowed, of course, obviously in something you drink. Okay.
I don't want to drink sewage sludge.
No. We definitely don't. I wouldn't recommend it. And we had an issue locally and in some other places where it was not being. It was some bad actors using it improperly, and so we had to regulate it a little bit more. So, okay. Thank you very much. Thank you, Mr. President.
Thank you, Senator. Senator from the 28th.
Thank you, Mr. President. A question for the floor
Senator, may
leader.
proceed.
Yeah, thank you. So this bill limits the amount of PFAS can be in sewage sludge that's spread on surface of land.
The senator is correct.
Okay. So under what circumstances are sewage sludge, which from our sewage plants, human waste, allowed to put on land?
So if it's between the 25 and the 50 parts per billion, that is like the gray zone. And that is where there are like specific setbacks that are aligned with the current like Class B allocations for spreading sewage sludge, plus some additional regulations.
Okay. So I'm not familiar with the Class B. Class B is?
I think Class B is in our current agricultural regulations.
Okay. So am I hearing that sewage could be spread in our agricultural land to grow our vegetables and fruits? Human sewage?
So this is like kind of a current practice, I believe. We are currently using sewage sludge as a form of recycling because it's got nutrients in there and the price of fertilizer has gone through the roof recently. And so what we're trying to do is to make sure that we can still recycle that sewage sludge, but we are testing it to make sure that the concentration of PFAS and PFOA is not too high.
Yeah, thank you for that. I understand that. And as a avid gardener, I went to a home improvement store a few years ago, and there was this great big bag of compost for sale. I was like, wow, this is a good price. And like, how do they do that? And I looked, it didn't say where it came from. I investigated. It turned out it was from a sewage plant in Minnesota, and that they kind of selling in Maryland. And I'm like, there's no way in hell I'm going to put sewage in my garden at home. There's no way I'm going to fertilize my garden with sewage, with human sewage. I understand, from chicken, plants, stuff like composted, that is more acceptable. But I'm really surprised to know that we're putting sewage sludge on our food system. We allow that in Maryland. Is that understanding correct from?
That is current
That's
practice.
current practice, yeah.
And so what this bill does is it requires the wastewater treatment plants to test for this product before it can be, because the phosphorus and the nitrogen in the sewage sludge is like highly beneficial, and that is what is like driving up the price of fertilizer right now. So it's kind of like you either put the fertilizer on or you put the sewage sludge on. Either way, you have to do a nutrient management plan. But we are going after the PFAS and the PFOA compounds specifically and making sure that they are not too high before we apply it to the land. There's additional setbacks. I'm trying to remember what they are, but a certain distance from private residence, certain distance from a private well. So we are definitely making current practice much more much safer for our farmers. There was a situation in Maine where they actually had to close one of these farms, and so we're. Did that answer the senator's question?
Yes, thank you for that. I'm just kind of wondering if we don't have, with all our chicken plants in Maryland, if we don't have enough, say, manure from our chicken plants so we can use it on our agricultural crops, especially vegetables, and why do we need to use sewage? And in addition to PFAS, sewage has a lot of other human substances. Talk about remnants of birth control pills. You have E. coli, just a lot of dangerous substances in there that a lot of times composting can't really get rid of. And you talk about psychedelic drugs, and all that is in our sewage that goes through human. Of course, animal like chicken waste is much better to use because we don't give chickens don't take really birth control pills and psychedelic drugs and all these other things. And so I'm really surprised. Mr. President, could I special order this bill for possible amendment until tomorrow?
Senator can make the motion. A layover might be more.
Layover.
If the senator moves to lay over the bill, the motion would be in order. We take up the bill and the amendments at the next session.
I'd be happy to talk to Senator offline. Thank you.
Wonderful. All right.
Thank you.
Clerk will read the next bill.
Senate Bill 829, Senator Waldstreicher, Land Use, Multifamily Developments, and Mixed-Use Developments Authorization, Bring Back Main Street Act, favorable with 2 amendments.
Recognized Senator from Baltimore City is the floor leader.
Thank you, Mr. President. As amended, this bill requires DHCD to conduct a study of residential in commercial zone laws, which authorize residential development as a permitted use in some commercially zoned areas. The department must report its findings and recommendations to the governor and the General Assembly by December 1st, 2026. There are 2 committee amendments. The first one alters the bill's title and makes technical changes, and then the second one strikes the language of the bill and instead requires DHCD to conduct this study. I move adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 829 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 861, Senator Zucker, Environment, Stormwater Management, Agricultural Land, favorable with 2 amendments.
Recognize the chair of the committee is the floor leader.
Thank you, Mr. President. As amended, Senate Bill 861, which passed unanimously out of the committee, requires the Maryland Department of the Environment to adopt regulations that consider certain best management practices for stormwater management practices for agritourism. There are 2 committee amendments. Amendment number 1 is technical. Amendment number 2 strikes language that would have required stormwater management regulations to be enforced on agricultural land in a certain manner, and instead establishes special considerations for stormwater management for agritourism as specified. The amendment also requires Montgomery County and the Montgomery County Soil Conservation District, in consultation with the Maryland Department of Environment, to review the county's current process for evaluating stormwater management plans for agritourism and report its findings to the governor and the General Assembly by December 31st, 2026. Mr. President, with that, I'd move the 2 committee amendments and the favorable committee report on Senate Bill 861.
Floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 861 is hereby ordered printed for third reading. Let's go to report number 13. Clerk will read the first bill.
Senate Bill 7, Senator Simonaire, Higher Education, Douglas J.J. Peters, Veterans of the Afghan and Iraq Conflict Scholarship, repeal of termination date, favorable with 1 amendment.
Recognizing the bill sponsors, the floor leader.
Thank you, Mr. President. This bill simply removes the termination date from the Douglas J.J. Peters Veterans of the Afghan and Iraq Conflict Scholarships. Currently, it expires in 2030. No other scholarships have a termination date, and it's been extended several times. And this will give military families certainty that the scholarship will be there. It was widely supported, no opposition, passed unanimously. There was 1 amendment to add co-sponsors. I move the amendment and the favorable committee report.
All right, floor leader moves for the adoption of the 1 committee amendment and the favorable committee report. On the amendment, yes, recognize the senator from District 6.
Thank you, Mr. President. I talked to the sponsor. I'd like to special order, if it's the right time, for an amendment for a sponsor. And I'm just putting it out there. If anyone would like to do the same, they can get with me. We can also add their names, but I'd like to do that with the bill. Thank you, Mr. President.
Any objections to the senator's motion? All right, without objection, we will special order the bill to the appropriate time at the next session. Clerk, read the next bill.
Senate Bill 198, Senator A. Washington, Prince George's Community College Aerospace and Aviation Systems Technology Program, feasibility study, favorable with 3 amendments.
Recognizing the senator from the 23rd as the floor leader.
Thank you, Mr. President. Colleagues, this bill requires the Board of Community College Trustees for Prince George's County, in consultation with Maryland Higher Education Commission, the Maryland Department of Commerce, and Prince George's County Economic Development Corporation to establish an aerospace technology studies program at Prince George's Community College, subject to program approval by MHEC. There are 2 committee amendments. The first is technical. The second strikes the bill as introduced and requires Prince George's County Community College to conduct a comprehensive feasibility student program design assessment to establish an aerospace systems technology workforce training program and an aviation system technology workforce training program. The community college must submit a report to the Education, Energy, and Environment Committee and Ways and Means Committee on or before December 1st, 2027 of the results of the study. The governor is required to include $100,000 in FY28 budget for the study. I move adoption of the 2 committee amendments and a favorable committee report.
Floor leader moves for the adoption of the 3 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 3 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title?
I have an amendment.
Yes, recognizing the senator has an amendment. Pages will collect and distribute the senator's amendment. Just a moment, senators. Pages. Looks like a complicated one. Recognizing the maker of the amendment.
Thank you, Mr. President. This is a technical amendment that adds co-sponsors.
Excellent. Any objections? Without objection, the amendment is adopted. Any further amendments to the bill or its title? Seeing none, Senate Bill 198 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 535, Senator King, County Board of Library Trustees, membership, student member, favorable.
Recognize senator from the 38th as the floor leader.
Thank you, Mr. President. This is a great student bill. What this bill does, it authorizes a County Board of Library Trustees to provide for the selection of a student member. The bill also establishes the qualifications, term of office, and voting rights of the student member if selected. There are no committee amendments, and I move adoption for a favorable committee report for SB 535.
All right, floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 535 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 670, Senator Kagan, Election Law, Local Boards of Elections, Employees, Authority at Polling Places, favorable with 2 amendments.
Recognizing the bill sponsor as the floor leader.
Thank you, Mr. President. Colleagues, the Maryland Association of Election Officials, the leaders in each of our 24 jurisdictions, have asked for more help with keeping our polling places safe and under control. Right now, it's only the election judges that can do this and can ask somebody to leave or to pipe down or stop disrupting or trying to talk to a voter. And so this just really expands that to the local election administrator or their designee. As amended, it also includes our State Board of Elections administrator or designee. There was no opposition to this bill. I move adoption of the 2 committee amendments and the favorable committee report.
All right, floor leader moves to the adoption of the 2 committee amendments and the favorable committee report. Recognizing the minority whip.
Thank you, Mr. President.
Question for the floor leader?
Yeah, I think I'd like to ask a couple questions on this bill.
Sir, may
the floor
proceed.
leader. So I understand I think I know the impetus a little bit for this, just because we obviously want to be sure that when folks are operating at a polling site that are supporting a candidate outside or are inside as challengers, that we have a clear line of sort of authority. And while we have that in law already, it looks like we're trying to tighten it up. Is fair to say, or?
Actually, it's the exact opposite. We're trying to expand it.
So we're trying to expand authority for who in this bill?
So right now, it's election judges who have the authority to enforce the laws within a polling place. And sometimes the election judge is working with a voter, helping someone with disabilities, trying to help a polling clerk or fix a scanner that's broken or otherwise busy. So this just says that the head of the local county board of elections or their designee, and then as amended, the state board of administrator or their designee would be able to also just provide extra staff, extra enforcement. In these divisive times, we just don't want to have problems at the polling places.
The local election director, would that be the head of the local board? Would that be the employee that's the director of the board?
That's correct, or their designee.
So their designee could be another staff member?
It could be a board member, but we just want to expand it beyond a judge who might be too busy to really be effective.
I'm envisioning that when you have election day, you have less of this because you're not going to have, you'd be spread too thin, correct? Or are we envisioning where the election director would designate somebody for every polling place?
I think it would be up to that person to designate as needed, but remember this would cover early voting as well.
Right, and in that case, I can understand the director's probably on site at one of the 3 or 4, however many, maybe even bouncing around. I don't know that I have so much of a question about the director themselves, but if we're allowing them, right now, would the local board have to empower them to do this, or can the local board empower them to do this if we don't pass a bill about it?
Current law, and this is an emergency bill because we want to make sure that it applies for our maybe it's a June 1 effective date. We want it to apply right away to this year's primaries. We want to make sure that there is peace and safety and that everybody can cast their vote during early voting or on election day. I feel like I missed your question. Would you mind repeating it?
No, well, I make it, right now, so right now you're telling me that we're not supposed to say you're, yeah. Right now the member, in our discussion, I'm hearing that currently the early voting site or a polling place on election day is only under the control of the people who are there on site that are the local, or is it only under the control of the board, the local board?
So right now, current law, it's an election judge who can do enforcement. I want to read some of the violations.
The on-site, well, hold on. If you don't, well, no.
No,
sorry.
go ahead.
Yeah. I know there's been some problems, so I'm definitely not questioning that. I think the question would be, right now, under current law, the person, is there one election judge per site?
Generally, there are
Head
multiple
judge?
election judges per site because
Okay.
we have multiple parties, and so there is there tend to be,
Right.
2 generally.
2. Okay. And you're telling, the assertion in the bill is that the election director for the county can't show up and also do that?
Currently, they would not have that authority.
Aren't they the ones who pick the judges?
I
mean, not pick, but doesn't the local board give the judge the authority? The judge is a volunteer, well, not volunteer, they're compensated very, very slightly, but the board, the county board is who authorizes you to be a judge, if I'm not mistaken.
That's correct, but that doesn't mean they've got the authority to throw someone out or get police involved if someone is destroying voting equipment, disrupting, trying to communicate or interfere with someone who's trying to cast a ballot.
So right now, under current law, and oftentimes there will be a police officer near or on site, under current law, there's not a way for the board to, no, I'm sorry, not board. Under current law, the election judge, and you're right, I think there's usually 2, there's usually 1 from each party is there.
Correct.
They can tell the police to take somebody out, correct?
Correct.
But the assertion I'm hearing is that if the director of the board is there on site, they can't also tell the police to take somebody out?
Again, the election head for the county or their designee, so that doesn't have to be, I mean, Montgomery County has a whole
I
bunch of
understand.
early voting, and
Sure,
then we have
sure.
hundreds of polling places. So it can be their designee. This is a problem where within 100 feet of a polling place, if they are interfering with an election official, if they're electioneering within the no electioneering boundary, if they're tampering with election records, concealing, damaging, or destroying voting equipment, tampering, removing equipment or supplies. There are a bunch of laws that need to be enforced, and we want to make sure that we've got sufficient people to keep our polling places safe on Election Day and during early voting.
But right now, under current law, you can't designate somebody already?
Correct. It's just an election judge.
And then is there any regulation in the bill, and I'm looking at it, but is there any regulation in the bill about who the state administrator or the county administrator can designate?
It does not. It just says, or their designee. So presumably it would be someone else who's in the polling place. So if the judges are busy helping a voter or something, that there's someone else on site who can be helpful.
I guess it sounds, I mean, I guess our challenge is we have trouble recruiting enough election judges. So how are we going to find designees if we can't find judges?
Well, that's one of the challenges. We have to, but they are well-staffed. People in our local boards of elections work all year to get folks to, I would say volunteer, but they're not. We keep increasing the pay. We want to offer the incentives. We also have students that help keep the peace and give out the I voted stickers, and we do have reasonable population, but we need to authorize the right person to be able to enforce these laws.
The bill, thank you. The bill also gets into how you become an accredited challenger, and it requires some paperwork, which I actually understand because we don't want people. We've seen in Minnesota, for example, people showing up and harassing federal agents and saying, I'm an observer, I'm an observer. It's like, well, you don't just get to show up and get in the middle of things if you're an observer. You have to have a process for doing that, and we don't want that with election stuff either.
Amen.
Agreed. So that's good part of the bill. I was reading through that. But I did wonder about the commanding of police officers. So right now, under current law, the election judges can tell a police officer not what to do, but they can order a police officer to enforce an election law inside the polling place. This is going to expand that to other people, but it would be the designee of the election director.
Got that right.
Okay. I guess as I read the bill, can you assure me that we're not putting the county administrator at a position where they are above the local board in this chain of command? Because it looks like it used to be the county. There's some spots where it says the county board or the local board could do X, Y, and Z, and now we're saying the local board or the county administrator. I may not be using the right terminology. Election director.
So this isn't going to be a random person. This is going to be an employee who's been trained. And just because law enforcement might be brought in to keep the peace, to stop the destruction of equipment or interference, that doesn't mean an arrest.
No, I understood. Okay. I tell you what, Mr. President, it's been a lot of amendments, and I think there's some things in the bill that are needed, but I do have a couple of sort of chain of command type questions. So I wonder if I could have the bill and the amendment lie over under the rule.
Senator's motion is in order. The bill and the amendment will lie over under the rule.
That's fine. Thank you.
All right, clerk, read the next bill.
Senate Bill 697, Senator Feldman, Election Law, Actions to Influence an Election, Social Media Platform Algorithms and Bots Purchased by Foreign Nationals, favorable with 2 amendments.
Recognizing the chair of the committee is the floor
Yes,
leader.
thank you. Thank you, Mr. President. Just a little context. Earlier this session, we passed a deep fake bill in the electoral process. Senate Bill 141 passed unanimously out of the body, 44-0. And it should have become apparent at that time that we've entered a new age when it comes to how democracy and the theory of free and fair elections can be skewed and mucked up by new technologies, and we've got to stay on top of it. And so this bill, Senate Bill 697, is directed at a few aspects of emerging and potentially dangerous role of social media platforms in our electoral process. Specifically, Senate Bill 697, which had no opposition and passed unanimously out of the committee, establishes specified circumstances in which a social media platform is presumed to have made an independent expenditure if it knowingly and purposely alters its algorithm to amplify political content beneficial to a clearly identified candidate for public, state, or local office for purposes of influencing an election. And secondly, establishes penalties for making such an independent expenditure and failing to comply with independent expenditure reporting requirements. Secondly, Mr. President, to protect against the influence of a foreign government, China, Iran, North Korea, the bill also prohibits a foreign national, which includes a foreign government, from using a bot to, number one, publish, distribute, or disseminate campaign material in the state to influence election, or secondly, artificially amplify political content to users of an online platform to influence an election. Mr. President, there are 2 amendments. Amendment number 1 adds a co-sponsor. Amendment number 2 adds to the definition of social media platform and corrects terminology to conform to how other states are defining social media platforms that have similar bills. Mr. President, again, there was no opposition to the bill. It passed unanimously. And with that, I'd move adoption of the 2 committee amendments and the favorable committee report. Thank you, Mr. President.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 697 is hereby ordered printed for 3rd reading. Clerk will read the next bill.
Senate Bill 848, Senator Gallion, Municipal Elections Information on Candidates and Voting Procedures and Locations, favorable with 2 amendments.
Recognize the bill sponsor as the floor leader.
Thank you, Mr. President. This bill requires a municipality to submit to the State Board of Elections at least 6 months before the candidate filing deadline for a municipal election the qualifications to be a candidate for each office on the ballot. Within 1 week after the candidate filing deadline, a list of each qualified candidate for each office on the municipal ballot and information on how to vote and where to vote in the municipal election. The Board of Elections must publish this information on their website immediately after the information is submitted by the municipality. There are 2 amendments. Amendment number 1 is technical. Second amendment alters the date by which a municipality must submit the qualifications to be a candidate for each of the offices on the ballot in a regular election to 3 months instead of 6 months. It also requires a municipality to report specified information to the board for a special election, and it alters the date by which the municipality must submit certain information, including party affiliation for partisan elections, to the state board from 1 week after the candidate deadline, filing deadline, to 10 business days. I'd like to move adoption of the 2 committee amendments and ask for a favorable committee report.
Floor leader moves to the adoption of the two committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the two committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 848 is hereby ordered printed for third reading. Let's go to calendar 14. Clerk, read the first bill.
Senate Bill 40, Senator Sidnor, Baltimore County Board of Education, alterations of elected member districts and establishment of redistricting process, favorable.
Recognize the Senator from Baltimore County's floor leader.
Thank you, Mr. President. Senate Bill 40 requires beginning with 2034 general election, the members of the Baltimore County Board of Education currently elected from each of the 7 councilmatic districts in the county must instead be elected from each of the 7 school board districts established through a specified redistricting process. There are no committee amendments, no fiscal impact, and I move the adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, Senate Bill 40 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 98, Senator Sidnor, Baltimore County School Board Nominating Commission membership alterations, favorable.
Recognize the Senator from Baltimore County's floor leader.
Thank you, Mr. President. Colleagues, Senate Bill 98 adds 2 members to the Baltimore County Board Nominating Commission, and 1 replaces the membership of a member appointed by the Baltimore County Chamber of Commerce with a member appointed by the Greater Baltimore County of Commerce, the former successor organization, and 2 specifies the term of that seat. Lastly, the bill staggers members' terms by specifying members whose term must terminate at the end of September 30, 2028, and other members whose term must terminate at the end of September 30, 2030. There are no committee amendments, and the fiscal impact is none, and I move the adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title?
Mr. President.
Yes, recognizing the Senator from Baltimore County has an amendment.
Thank you very much. I do have an amendment.
Pages will collect and distribute the Senator's amendment. Give us just a moment. Senator, explain the amendment.
Thank you very much. There was an error in the way that we misnamed the Chamber of Commerce. So what this amendment does is strikes the word county from behind Baltimore.
All right.
I'll move the amendment.
Floor leader, or excuse me, the Senator moves the amendment. Any objections from the committee? No objections.
No, I consider that amendment friendly.
Friendly
Mr.
amendment.
President.
Any objections from the floor without?
I'm sorry, Mr. President, I couldn't hear
Senator
the
for a second.
analysis, the description of the amendment.
To the maker of the amendment?
Thank you very much. Within the bill, we wrote the Baltimore County, Greater Baltimore County Chamber of Commerce. The name is Greater Baltimore Chamber of Commerce, so it strikes county.
Excellent. All right. Any objections? Without objection, the amendment is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 98 is hereby ordered printed for third reading. Clerk, read the next bill.
Senate Bill 292, Senator Bailey, County Board of Education, Student Transportation, Sunset Repeal, favorable with 2 amendments.
Recognize the Senator from the 23rd as the floor leader.
Thank you, Mr. President. Colleagues, this bill repeals the sunset provisions of Chapter 197 and 198 of 2021, which authorize the County Board of Education to provide transportation for specified public school students to and from schools using a vehicle other than a Type 1 or Type 2 school vehicle, which means a yellow bus, when a school vehicle cannot reasonably be provided. Those acts required the Maryland State Department of Education to consult with county boards of education and the Motor Vehicle Administration to adopt regulations establishing minimum vehicle and driver safety standards for alternate student transportation. There are 2 committee amendments. First is technical. The second authorizes the County Board of Education to contract with a transportation network company or rideshare that does not meet certain standards adopted by MSDE and regulation to transport not more than 2 students at a time if the driver meets specified requirements, including completing a background check and fingerprinting based state and national criminal history record check. This authorization automatically terminates if MSDE adopts certain regulations following a mandated regulatory review of the regulations adopted by MSDE regarding minimum vehicle driver safety standards for alternate student transportation. There is no fiscal impact. I move adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 292 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 646, Senator King, Public Schools System Contracts, Prohibited Provisions, favorable with 2 amendments.
Recognized senator from the 41st is the floor leader.
Thank you, Mr. President. This bill prohibits specific provisions from being included in a public school system contract except as required by state or federal law. If a public school system contract contains one of those provisions, the provision is void and the contract is enforceable as if it did not contain the provision. There are 2 amendments. The first one is technical, and the second one exempts collective bargaining agreements. I move adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 646 is hereby ordered printed for third reading. Clerk will read the next bill.
Senate Bill 685, Senator Guile, Local School Systems, Sexual Abuse and Sexual Misconduct Response Policy and After Action Review, favorable with 2 amendments.
Recognizing senator from the 27th as the floor leader.
Thank you, Mr. President. Senate Bill 685, Local School System, Sexual Abuse and Sexual Misconduct Response Policy and After Action Review has favorable with 2 amendments. The bill requires the Maryland State Department of Education to develop a model of sexual abuse and misconduct response policy for use by local school system to respond to a credible allegation of sexual abuse and sexual misconduct. On the conclusion of the child sexual abuse or sexual misconduct case or a serious incident, a local school system must conduct an after-action review within 45 days of the conclusion of the incident. This bill has 2 amendments. The first amendment is technical. The second amendment strikes provision of the bill regarding the local school system webpage and prescriptive electrical document policy and after-action review report requirements. It also requires the model child sexual abuse and sexual misconduct response policy developed by MSDE to include a minimum of 4 components: a communication plan, an email and electronic document retention policy, a requirement to the link to centralize a resource platform developed jointly by MSDE and the Maryland Center for School Safety, and an after-action review plan. Each model response plan component must meet certain requirements and be developed in collaboration with entities described in the bill, and alter the date in which a local school system must adopt a response policy to September 1st, 2027, and require each local school system to post a link to the comprehensive resource platform on its website. And that's all the amendments. I move the adoption of the 2 committee amendments and the favorable committee report.
Floor leader moves for the adoption of the 2 committee amendments and the favorable committee report. On the amendments, any discussion? Any objections? Without objection, the 2 committee amendments are adopted. Question now is on the amended report. Any discussion? Any objections? Without objection, the amended report is adopted. Are there any further amendments to the bill or its title? Seeing none, Senate Bill 685 is hereby ordered printed for third reading. We have a message from the House. Madam Clerk, if we could read the message.
Here we go. House Bill 324, Delegate Simpson, Family Law, Child Support Assignments of Rights, Judicial Proceedings.
Majority Leader moves so we consider the reading of the bills. They are referred to their appropriate standing committees. We have a message from the executive. Clerk will read the message.
Dear President Ferguson, please accept the following administrative updates intended to align our previous nomination submission with record-keeping protocols and statutory requirements. Thank you for your assistance and support. Sincerely, Westmore, Governor.
All right, the message having been read is ordered journalized and will be referred to the Executive Nominations Committee. Madam Secretary, if we could please ring the bells. And Madam Clerk, if we could please do a quorum call.
Mr. President.
Thank you. All right. Has everyone recorded their presence? If so, the clerk will take the call. With 45 members in the chamber and a quorum being present, the Senate of Maryland remains in session. Let's go to third reading calendar number 4242. Clerk will read the first bill.
Senate Bill 282, the President Budget Bill, Fiscal Year 2027.
Senate Bill 282 is on third reading for final passage. Any discussion? If not, the clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? Yes, recognizing the minority leader has 2 minutes to explain his vote.
Thank you very much, Mr. President. Just in explaining my vote, I certainly appreciate the work of the Budget Committee and recognize that this year's operating budget avoids any broad-based tax and fee increases. But I want to be clear, I think that this is an election year budget, and it is not a long-term fiscal decision that I believe, again, we should have addressed in speaking about where we're going to be with the structural deficit approaching nearly $3 billion in the coming years. And unfortunately, as I said, I don't think this budget really clearly addresses that reality. So instead of making the difficult decisions now, these are being pushed down until next year. And I think this only becomes more severe and potentially more costly for Maryland taxpayers by not addressing it this year. So I think fiscal responsibility is not just about balancing the budget today, but ensuring sustainability for future years ahead. And unfortunately, I think this budget falls a little bit short of that, and for that reason, I'm voting against the budget.
All right. Are there any further senators who wish to explain their vote? If not, the clerk will take the call. With 40 votes in the affirmative, Senate Bill 292, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 284, the President Budget Reconciliation and Financing Act of 2026 on third reading.
Recognizing the minority whip on 284, third reading, final passage.
Thank you, Mr. President. And I know we had extensive debate on this yesterday, and I thought there was a lot of good dialogue and discussion. And I think it's a situation both with the previous bill and in particular the BRFA here, where philosophically what's happened is the state is able to balance the budget this year because of massive tax increases, tax and fee increases that have happened the last 3 years. And so for us to say that, you know, well, good news, we're not having a tax increase in this year's BRFA budget combo, that's positive. I think we've illuminated that, at least with what we're doing in the BRFA on the energy and SEAF, it's certain functioning like a bit of a tax increase as it relates to how we use SEAF funds. But we've got to move forward as a state. We cannot continue to add to the size and scope of state government. We have to make some very serious long-term decisions. And what I was hoping for, and we were not able to do in this process, was get some relief this year on some tax relief. Maybe roll back some of the things that we've put in place that are, for example, like the computer services tax that have turned out to not be what they were, the numbers they were hoped for, but also have, I think, been pretty clearly damaging to our business climate, our job creation climate. So I'm going to be voting against the BRFA, and look forward to, though, continuing this conversation, because we're going to be back. Maybe not all of us will be, but the people in this chamber next year are going to be, and taxpayers will be facing more serious challenges. So thank you, Mr. President.
Thank you, Senator. All right, further discussion on Senate Bill 284, third reading, final passage. If not, the clerk will call the roll.
Mr. President.
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? Chair, in explaining his vote, just want to thank all of the members of the Budget and Tax Committee, the chair, vice chair, the subcommittee chairs, to the analysts, the DLS. This is actually the fastest we have moved a budget out of the Senate, other than COVID year, which was pretty extraordinary. This was the fastest it has been moved. Still a ways to go. We have the House has to do their version. We have the conference committee, but a lot of work was put into this to kind of get us through what is a pretty uncertain year, and just want to thank the members of the committee and the Senate for their work on this effort. Recognized Senator from District 4.
To explain my
2
vote.
minutes to explain his vote.
Thank you. I do want to thank the committee and the chairman for coming and briefing us the other day on this. I know it was a heavy lift, and I appreciate the dialogue. I guess the one major concern I have is that as long as it took the committee and the chair and other parties involved, I mean, we had 13 hours to review this really lengthy, involved budget that increases the overall spending of the state by about 5%. So while we're not adding any new fees or taxes, we're still increasing the state's budget to $70 billion. And that's concerning for me, and I just wish that we had found a better way, a better path to have more than 13 hours to look through this document, because it is an extensive document. But I do appreciate the work of the committee, but because of those reasons, that's where my vote will be read on this. And I hope that we can have better and further discussions and dialogue in the future to find other ways to navigate our difficulties in the future. So thank you, Mr. President.
Thank you, Senator. All right, any further senators wish to explain their vote? If not, the clerk will take the call. With 34 votes in the affirmative, Senate Bill 284, having received a constitutional majority, is declared passed. All right, we're going to get through a couple third readers while we have everybody here, and we have 46 of us. So see how far we can get in the next couple minutes here. Let's start with third reading calendar 35. Clerk will read the bill.
Senate Bill 893, Senator Guile, Business Regulation Rounding Cash Transaction Authorization. This is an emergency bill.
Senate Bill 893 is on third reading for final passage. This is an emergency bill. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 35 votes in the affirmative, Senate Bill 893, having received a constitutional majority, is declared passed. Let's go to 36. Clerk will read the first bill.
Senate Bill 193, Senator Quarterman, Washington County Sales and Use Tax Exemption Target Redeveloper Area.
Senate Bill 193, third reading. Yes, recognize the senator from sponsor of the bill.
Yeah, thank you, Mr. President. I'd like to kind of special order this until sometime tomorrow.
Second, tomorrow. Any objections? Without objection, bill will be special ordered at the appropriate time tomorrow. Clerk, read the next bill.
Senate Bill 231, Chair, Budget and Taxation, Horse Racing Prohibited Acts, Slaughter of Racehorses for Commercial Purposes.
Senate Bill 231 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 45 votes in the affirmative, Senate Bill 231 have received a constitutional majority, is declared passed. Clerk, read the next bill.
Senate Bill 312, the President, Constitutional Officers, Salaries.
Senate Bill 312 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 39 votes in the affirmative, Senate Bill 312 having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 313, the President, Courts, Administrative Judges, Annual Stipend.
Senate Bill 313, third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote. If not, the clerk will take the call. With 44 votes in the affirmative, Senate Bill 313 having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 518, Senator King, Maryland Financial Empowerment Center Network Pilot Program Establishment.
Senate Bill 518 is on third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 518, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 748, Senator McKay, Correctional Officers Retirement System, Allegheny County.
Senate Bill 748, third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? And we should change their vote, explain their vote. If not, the clerk will take the call. With 46 votes in the affirmative, Senate Bill 748, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 833, Senator Hershey, Queen Anne's County, authorized uses of revenues from development impact fees expansion.
Senate Bill 833, third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 45 votes in the affirmative, Senate Bill 833, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 847, Senator Carrozza, Wacomico County Property Tax Credit, Salisbury Neighborhood Housing Services.
Senate Bill 847, third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 45 votes in the affirmative, Senate Bill 847, having received a constitutional majority, is declared passed. Clerk will read the next bill.
Senate Bill 851, Anne Arundel County Senators, Anne Arundel County Property Tax Credit, Rural Legacy Program.
Senate Bill 851, third reading, final passage. Any discussion? If not, clerk will call the roll.
Mr. President,
Has everyone recorded their vote? Anyone wish to change their vote, explain their vote? If not, the clerk will take the call. With 45 votes in the affirmative, Senate Bill 851, having received a constitutional majority, is declared passed. No, let's just call it. All right. A little bit later tonight, but Senator from the 22nd.
Thank you, Mr. President. I would like to be recording the green on Senate Bill 313.
313 in the green. Any objections? Without objection, so ordered. Senator from the 37th.
I'd like to be recorded in the green on Senate Bill 893.
893 in the green. Any objections? Without objection, so ordered. Senator Baltimore, 43rd.
Mr. President, I'd like to be recorded green at 313.
313 in the green. Any objections? Without objection, so ordered. Senator from District 2.
Yes, Mr. President. 893, I'd like to be recorded in the green.
893 in the green. In the green. Any objections? Without objection, so ordered. All right. We don't want to get hangry, you know. Feels like we're hitting the witching hour of might get a little spicy. So, all right, let's check with committees. Chair of Finance. Oh, let's think about timing. 5? 4:30? 4:30? Yeah. All right. Let's do 4. Okay, we'll come back at 4:30. 4:30 is good. Great. All right, Chair of Finance.
Thank you, Mr. President. I think we'll take a lunch hour and start at 2 today.
2 o'clock for Finance. Education, Energy, and the Environment.
Okay, we'll follow suit. 2 p.m. for Triple E for voting.
2 p.m. is the winner so far. Budget and Tax.
Thank you, Mr. President. I think 1:45 we will have Capital making its presentation, and then after that we'll be voting.
1:45 for Capital. Well, all right, let's check with Judicial Proceedings. Well, let's go back to Budget and Tax. We have a
revised.
We've got a revised answer. We've got a color page for the timing.
So 1:45 still. We'll do voting first.
Voting
Little
for
printing issue.
B&T 1:45. All right. Judicial Proceedings.
Thank you very much, Mr. President. The Judicial Proceedings Committee will meet today at 2 p.m. for a voting session.
2 p.m. for Judicial Proceedings. Other standing committees, select committees, joint committees, delegations. Yes, Anne Arundel County delegation.
Thank you, Mr. President. The Anne Arundel County delegation will meet in the Red Room for just a quick bill, hopefully, right after the floor.
All right, Anne Arundel right after. Prince George's County delegation.
Thank you, Mr. President. Prince George's delegation will meet at 6 p.m. in the Neal Room.
6 p.m. That might be tight. We can hold it for 6, but maybe after session. We'll see where we are. All right. Any other delegations? Caucuses?
Mr. President.
Yes, Minority Whip.
First of all, the Carroll County Senate delegation will not be meeting today. The Senate Republican caucus is going to have a meeting at 3:45 in our caucus room, depending on who's available and with voting. But to hold the 3:45 if you're able to come. Thank you.
3:45 for the Minority Caucus. Any further announcements? Any further announcements? If not, let's go ahead and do a quorum call.
Mr. President,
Has everyone recorded their presence? If so, the clerk will take the call. With 45 members in the chamber and a quorum being present, the Senate of Maryland remains in session, recognizing the Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand in recess until 4:30 this afternoon promptly.
Without objection, so ordered. See you at 4.
Wait. And also, you can leave your laptops here if you'd like this afternoon. The room will be secured.
Exactly. Perfect. Thank you, Madam Majority Leader. See you then. Have a good afternoon. We're adjourned.